we're at Murray versus Murray.
Yes. Again, good morning, Judge. We are the petitioners, and the hearing this morning is in reference to our request for a guardian ad litem to be appointed. And so I will swear my client in.
Before we swear your client in, Ms. Waters, give me a background on why you're asking for a guardian ad litem in the first place.
Yes. So, Your Honor, this case is divorce filed back in November of 2022. Miss Murray filed an answer to the complaint with Ms. Charles Singleton being her attorney. The last time we were in court, we were not able to proceed because Mr. Singleton was not in court, and we weren't sure if he was still a part of the case. Your Honor, you had indicated that you wanted to hear from Mr. Singleton with regards to his position. I believe that Ms. Murray had indicated that he only filed the answer and he was no longer her attorney. Since that time, I was able to speak with Mr. Singleton on just recently on Friday. We requested at that point in time a request for more time to do discovery because we had not received any discovery, and we also requested a guardian ad litem. And the guardian ad litem, because the child has been moved out of the jurisdiction of the court by Ms. Murray. She now lives over in, I believe it's Rockdale County. She initially, when she moved, the children was, the child was being picked up from school by Mr. Murray, and he was not sure that where she had lived initially until such time as Ms. Murray changed the school of the child to Rockdale County. And that's when he learned of the child being there. 5 years old. She has a sibling who is not the party's child, who is, I believe, 9 years old. And the children have indicated to Mr. Murray, and Mr. Murray has reason to believe that the children have been left alone in the home by themselves on many occasions. As a matter of fact, he believed that the child is at home after school. When they get home from school, they're home by themselves. That he has been speaking with the children on, or his child, the 5-year-old, on FaceTime previously, whereas the children have been in the home by themselves. And so we've asked for a guardian ad litem to be appointed because we need to know. She is indicating that that's not so, but the children are saying something different. And because he has no access to knowing or understanding, he's very concerned about a 5-year-old being in the home alone. And this has been a pattern even prior to this separation and pending divorce. And so we're asking that a guardian ad litem be appointed. The child was moved out of jurisdiction, and we have not raised that issue because we haven't been in court, and we didn't file any motion on that, but she is not currently in the jurisdiction of this court.
All right, Mr. Simpson.
I mean, Your Honor, my client lives in Conyers. The petitioner is in Stone Mountain. It's 17 miles door to door from petitioner's house to my client's home. He has unfettered access to the children. He has visitation with the children on a regular basis. We provided the petitioner's attorney with the name of the caretaker who cares for the children after school. Ms. Murray is also attempting to get verification from the school when the neighbor who is caring for the children after school, literally next door, they're in a townhome. She shares a wall with this neighbor. Then she pays for aftercare at the child's school. Miss Murray has also offered the petitioner the opportunity, if he wanted to pick up the child after school. We're not talking out of the jurisdiction like the child lives in Macon. She lives approximately 20 to 30 minutes from the petitioner. And he's indicated, I guess, that he's unable to do that. But Ms. Murray has offered that as a resolution at some point. We don't believe that a guardian ad litem is required. We believe the court can make the decision when we have a final as to custody. for many reasons. So we oppose it on that basis, and Ms. Murray will offer testimony to that effect.
Ms. Waters, if it's this one issue dealing with whether the children are alone or not, why do you believe that's something the court cannot interview the children about?
Well, we believe that the children the court can make a decision as to whether or not the court can essentially talk with the children, I guess, in chambers to find out if that is the case. So yes, the court can do that. But I do want to bring to the court's attention that this was only Friday that we were offered this information, and I was not feeling well over the weekend. Like yourself, I've been suffering with some upper respiratory issues, and so I wasn't able to get back with Mr. Singleton, but I had not spoken with him at all since the last time we were in court. I did reach out to him, and I have not spoken with his client, because she indicated that he was going to come back in on the case. He did file a motion in opposition of the garden ad litem, but in the alternative, we'd like to get to some resolution. And by the way, Judge, there was no order of who was going to have custody of the child ever. And so she just taken it upon herself to take the child away from the father. And he was spending about half the time with the child. And then she decided that he couldn't have the child whenever she didn't want him to have the child. She would withhold the child from him. And that is an issue with the child being out of the jurisdiction of this court.
When did she remove the child from the jurisdiction of the court? Before the divorce or after?
After, Judge. This was all after the divorce was filed.
So after the divorce, then she moved to Rockdale.
That's correct, Your Honor. And Your Honor, you sent us to mediation. We thought that we had an agreement, and we did have an agreement. And then she asked that she not sign that. I mean, she didn't want to go forward with that agreement because her lawyer was not there again. This is the first time Mr. Singleton has appeared. And so I had no way of knowing whether or not he was in on the case or not. She indicated in mediation that he was no longer her attorney. So that's why she appeared pro se. So we've gone back and forth.
What's the visitation going on now?
Well, what was happening is that they were doing a co-parenting situation whereby Mr. Murray would have the child on Thursday, Friday, Saturday, Sunday, and then she would have Sunday, Monday, Tuesday, Wednesday, and then drop her off at school. And then if she was at school, he would pick her up from school, but if she was at home, he would pick her up from home. They are in a gated community, so the last time he picked the child up, no one was at the bus station to see these children when they got off the bus, which is at the front gate of the complex where she lives. And so he picked the child up and tried to make sure that the other child, the 9-year-old at least, was walking toward the house and seemed to be safe before he drove off. So apparently she doesn't get off until 6 o'clock, but we just learned of this person. She never said anything to Mr. Murray about, I have a babysitter. She has never said anything about the child being in after school care. She has not indicated any of that. And as a matter of fact, they talked about Thanksgiving, and he was going to have the child on Thanksgiving. And then she just decided that she wasn't going to let him see the child on Thanksgiving, which he did not. He had the child on one weekend about 3 weeks or a month ago, and the child was sick. So he had to go into work, drop the child off at his aunt's house so that she can care for the child for a few hours while he went to work. Well, Miss Murray called the police and had the police to go to his aunt's house to get the child. So yeah, there is a lot going on, Judge, and we just need to have some, orders from the court in terms of how this should happen. And we thought that the shared parenting was working, but when Miss Murray gets mad with him, I guess she just yanks the child from him. And so that is a problem.
So for right now, they're splitting the weeks.
Correct.
Are they still doing that?
No, they're not. And that's not because Miss Murray declined. He indicated that he was seeing them on the weekends, every weekend. And it's my understanding he initiated that he couldn't see them every weekend, so he's seeing them every other weekend. That's the current visiting schedule.
Okay, what? So the current eviction schedule right now is every other weekend.
Well, according to my client, he was picking up his daughter every Thursday from school.
Is that the plan he wants to be on?
Yes.
It's from Thursday to Monday.
Or Sunday evening. But he could drop the child back off at school on Monday mornings.
And Mr. Singleton, what is your client's position on the Thursday to Monday?
We haven't discussed it, but I don't know that he can drop the child off at school on Monday because he has to be to work at 6 a.m. is what my understanding is. So he can't drop the kid off on Monday, possibly return her home Sunday evening so that my client can take her to school would probably be better. And if you get your Thursday evening, I mean, there has to be a plan for her to get to school on Friday morning. It's our understanding it works from 6 a.m. to 2 to 3 p.m.
Okay, so let's do this. I'm going to combine it here so we can have some temporary visitation in place. So that's kind of that. My main focus is trying to put some visitation plan into place, a temporary on that, while you kind of work out some of the discovery issues that you have. I don't know about the finances of the party. I'm not really sure if a guardian ad litem is actually necessary if we're only talking about that one type of concept, because I can interview the children and or you all can bring additional evidence on that piece without a guardian ad litem being necessary. I hate to spend money when it is something that the court can take care of. So we're going to have we're going to give each of them 20 minutes and we'll see if we can come up with some sort of mediated or some type of temporary visitation until we work everything out. All right. Call your first.
Yes.
Call your client. Ms. Waters.
I'm sorry, Judge, I misunderstood what you said last.
Call your client so we can come up with what he would like the visitation schedule.
Mr. Murray, what is your decision with regards to temporary custody of the minor child?
I would love to have her living with me.
And could you tell me what that will look like in terms of what days where will she live, and then what days will she be with the mother, and then how will you get her back and forth to school?
When she was living here in DeKalb County, she was going to school 5 minutes away. And I'm able to get up in the morning, drop her off to school, then go to work, then leave work at 2 o'clock because I would take my lunch break at 2 and be able to reach home by 2:30 to get her. And so she will have somebody here with her during the evening, and her mother can get her on the weekends.
Can you tell me who would be at the home with her when you dropped her off from school?
When I get off originally from work, I work from 6 to 3. So I normally when I have that to do, I will just work from 6 to 2 o'clock and take my break at 2, leave, pick her up, come home. So I will be at the house with her every day during the school time. And on weekends, I'll still be home with her unless she's going to be with her mom.
And so in the current arrangements right now, what are your availabilities with regards to getting the child to school and picking the child up from school?
I work Sunday to Thursday. I'm off on Fridays and Saturdays. If I get her on Thursday evening, I would be able to drop her off at school on Friday mornings. And her mom can get her back on Sunday.
Okay. And so
what time on Sunday?
I can drop her off by the latest 6 o'clock on Sunday.
AM or PM?
PM.
Now, do you work on Sundays?
Yes, I work, Your Honor, from 6 to 3 on Sundays.
So where would she be while you're working?
She'd be at the house with my son, with her brother.
And how old is your brother?
16.
So the point of her being there is what if you're not going to be there? Gone with brother?
She will only be here with him on Sundays while I'm at work, or I left her with my aunt last time, but she went there, brought the cops, brought the police, and took her away from my aunt.
You work from 6 to 2 each day, is that right?
Yes, ma'am.
You're telling me you can leave at 2 o'clock every day?
Not every day. Some days I leave at 2, some days I leave at 3. It depends on if I work through the day and not take a lunch break. If I do not take a lunch break, then I leave at 2. But if I take my lunch break, then I leave at 3.
And then what time do you get her?
I got from work to home. I get home at 3:30. But if I leave at 2, I get home at least 2:30, depending on traffic.
If you leave at 3, where do you pick her up from?
When I'm picking her up, right now, I only pick her up on Friday. On Friday, when it's my weekend, I pick her up from school on Fridays. And then I drop her back off on Sunday.
If she lived with you?
If she lives with me.
What would you do on the days you have to work till 3?
Well, in that case, Your Honor, I would not be working till 3 because I know I have to pick her up. So on those days, I would work from 6 to 2 so I could get off at 2 to be able to go pick her up from school.
So you're telling me you can decide what days to work up to 3?
No, whenever I have my child with me, Your Honor, I will work from 6 to 2. As long as she's with me, I will work from 6 to 2 so I could able to leave work to come and pick her up from school.
What kind of work?
Could you repeat that?
What kind of work do you do?
Shipping and receiving. I work in a warehouse.
And you're able to leave every day at 2 if
I have to go pick my kid up. Yes, Your Honor.
And your job is okay with that. It's not considered an issue.
No.
It's not gonna be considered a demerit. It's not gonna be stress. It'll just be what it is.
Oh, Your Honor, because I mean I still get 1 hour break, lunch break every day.
Yes, and you're telling me that there are no issues with that.
No.
So prior to your wife coming and removing the child and taking the child to Rockdale, you were coming home every day at 2.
Yes, Your Honor. When I have to pick her up from school, I leave at 2.
If you did not have her full time, what you're saying, you were able to get her on Thursday and return her to her mom on Sunday?
Yes, Your Honor.
Okay, thank you. Ms. Waters, if you have any additional questions, you may ask them.
I don't have any additional questions to ask Mr. Murray with regards to the temporary arrangements that the court is seeking, but I would like to know, ask Ms. Murray some questions about her employment and what time she worked and how the children are.
We'll get to her in a minute. Mr. Singleton, do you have any questions for Mr. Murray?
Mr. Murray, were when we're talking about you picking the child up, I'm sorry, dropping her off at school in the mornings, are you referencing where she's currently enrolled in school, or would you be moving her to DeKalb County to school?
I was referring to when she was living here in DeKalb County, and also if she is to live with me right now, that's what would happen, sir.
And what school is that?
Uh, I don't remember the name of the school right now off the top of my head, but it's just right down the street from me.
By the name of the school you're going to previously? You don't know the name of the school?
I don't remember, right? I have so many things going through my head right now, Your Honor. I don't remember off the top of my head. Woodridge Elementary.
Okay.
And what time it takes in on at Woodridge?
Could you repeat that?
What time? What's the earliest you can drop her off?
7.
So how do you get to work at 6 if you got to drop her off at 7?
Your Honor, at that point, I had during that time I had worked out something with my supervisor, because he's very understanding, especially when it comes down to kids. So I had worked out something with him where I could drop whenever I have to drop her off. If her mom wasn't able to drop her off, I would drop her off and go to work, then leave work to come get her.
Wait a minute.
So where do you work? I'm sorry, Your Honor,
You would leave work to come back and drop her off at 7, go back to work, and then leave early again to pick her up?
No, Your Honor. I work from 6 to 3, so I will drop my daughter off on my way to work, but I will go in late, drop her off to school, then go to work. Then I leave at 2 o'clock to be able to get back over this side by 2:30 to get her from school.
I don't know what you're doing, Mr. Murray, because you're losing 3 hours a day. If that's what you were doing, is there something you're leaving out? Because
no, I'm not leaving anything out, Your Honor. Remember, I get an hour lunch. It takes me 20 to 25 minutes to get to work from where I live. So I mean, in the morning,
if you have to be to work at 6, your daughter has to be to school at 7, and it takes you 30 minutes from dropping your daughter off at 7 so that you can get to work. You can't get to work till 7:30, which means you're already an hour and a half late. Then you have to leave at 2 to get back on the other side of town. So every day you're missing 2.5 hours of work. Is that what you're telling me?
Yes, ma'am.
And
that's what I had to do when I had to do it to be able.
And when were you doing that?
When she was living here before her mother moved out.
What time frame is that?
That's last year. Before she moved out on the 1st of December last year, so that's January to November.
So for a year, you were missing 2.5 hours of work.
Not every day, Your Honor, because I only do it when her mother has to, she has to leave for work early, or she has something other else to do. So I just fit in and drop her off. She asked me to drop her off at school, so I just drop her off.
So there were certain days that she was dropping the kid off.
And she drops them off on Mondays to Thursday, and on Friday morning I drop her off. But in case during the week she can't, then I just go in late. So I don't do it every day.
Right. So when you're asking for full custody, you're asking for full custody with the understanding that Ms. Murray would be helping you get the child to school.
No, I'm not. No, I'm not expecting her to. I have my son, Your Honor, and at that point, my daughter can ride the bus to school. When I have full custody, my son can take her to get her on the bus, and then I'll pick her up from school after work.
Okay, thank you. Go ahead, Mr. Singleton.
I don't have any other questions, Your Honor, of him. So.
Please ask questions from Ms. Murray.
And what do you do?
I am a business travel manager, as well as entertainment and sports for IHG Hotels.
Okay. And what hours do you work?
I work from 9 a.m. to 5 p.m. and I work from home sporadically during the week as well.
So can you tell the court what has been the visitation schedule and that you and Mr. Murray have been abiding by?
So currently, Mr. Murray is seeing Selah Friday evenings. He picks her up from school and drop her home on Sunday by 5 or 6 p.m. Previously, he had weekly visitation, picking her up Friday and dropping her off on Sunday, until Mr. Murray recanted that decision and decided to only pick her up every other weekend on Friday to Saturday, or Friday to Sunday, I should say. I did offer for him to pick her up from school in the afternoons, and he declined that offer, saying he's not driving to pick her up from school. That was my choice to move her to a different district. So I had to make the decision to find an aftercare individual to assist me with her and also pay for aftercare fees. So on the days that I'm not working from home, which is again sporadic, I may choose a Monday or a Tuesday or a Wednesday or a Thursday, Friday. My next door neighbor and I work the schedule out because she's an at-home parent with her 2-year-old son. During the week, she goes to school at anywhere between 7 to 7:35, and she is out at 2 p.m. And I am usually home if I'm not working from home, or Anna Lewis, which is my neighbor, assist with that. And again, sporadically throughout the week, if she's not available in the evening hours, or I'm not able to get home in a timely manner for them to get off the bus, then she's in aftercare like she is today.
Did you refuse to allow him to continue seeing the children? I'm sorry, your daughter every weekend?
No, he decided to decline that offer, and I believe I provided proof to yourself, Mr. Singleton, and the court, where he did recant his decision to not see her every week and decided for every other weekend instead. And his every other weekend visitation that he decided was from Friday evening. He would pick her up directly from school, where he would either check her out at 1:30 or pick her up from home and return her back on Sunday evening at 5 to 6. And this was directly a decision that he made. I did not decline his offer on a weekend or weekly basis.
All right. To the best of your knowledge, is it possible for him to have dropped your daughter off to school this past year?
No. Previously, Mr. Murray was not.
Ms. Murray, 1 second, please. Give me a moment.
When you all were either in the same place, when did he ever take her to school?
Very rarely, because my hours during the time was from 5 p.m. From 5 p.m. to possibly 2 a.m. I was the head member manager for a private elite membership club at the time. And I chose those hours specific to my husband at the time, Christopher Murray. He was working from 6 a.m. to 2 to 3 p.m. in the afternoons. So my duty to balance family and making sure our children was taken care of, I assumed a position that required me to work from 5 p.m. to 3 a.m. in the morning. And because of that, I was able to be there for my children around the clock, from the time they had to be in school to the time they had to leave school. And that was due to the decision of my children's school hours. Upon the divorce, being filed. And prior to me moving out, I acquired a new job that, again, would be in line to my children's school hours, which is from 7 a.m. to 2 p.m. is when they get out of school. So then I'm able to drop them off on time every morning, and I'm able to find assisted coverage for them in the afternoon hours when I'm not present. And that's when I extended my hand out to Mr. Murray and asked if he could pick her up from school in the afternoon. And he declined and said he would not be picking her up and he will not be seeing her every weekend. I provided that material to the court and yourself, Mr. Singleton, I believe. If not, I can resend it. But he then assumed every other weekend for Friday to Sunday evening only.
All right. How do you respond to the insinuation that you're leaving the minor child home alone in the care of your 9-year-old daughter?
That is false. My neighbor, again, is Anna Lewis. She is directly next door to me. We share the same wall, same fence. So what happens is my kids, they come home and they go directly to her door. Snacks are provided, drinks are provided, and their homework is completed majority of the time. If not, I like to get homework done with my kids in the evening when I get home. So they usually like to wait for me to come home to finish that better half of the evening. But if not, they're in aftercare when she has to care for her son or take care of any other family activities for herself. And that's where I have to pay a $15 a day for Selah for aftercare plus registration. And I also did inform Mr. Murray of that as well.
Miss Murray, child in your home and Anna has access to your home, or is the child going to Miss Anna's home and staying there until you get home?
Yes, Your Honor. She goes directly to Anna Lewis's home every afternoon with her sister, who's 10 years old.
So she does not go home and Miss Anna comes over to check on her. She goes
they go directly to her house. They have the access code to her door. They don't have to ring the bell. They literally go right inside and they change. They have a change of clothes over there. They have snacks, drinks, and everything. And also Anna Lewis have access to my home. She also have my door access code where she can come in if there's anything that they need.
Okay.
I don't have anything further, Your Honor.
Now, why did you move the children to Rockdale if you all were in the...
I, at the time, could not find a safe community for my children in that Stone Mountain area. In the school that they were attending, the teacher at the time that had my youngest was leaving because of her views of the school. They just did not have the best reputation at the time. So I made the decision to move them into a better school based on recommendations from other teachers that attended the school and the program at which my daughter is currently in. She's an honor roll student, and she's currently, registered to go to a middle school for next year. So I felt at the time it was best for her to go to a better school and still have access to her dad, because I work in Atlanta, I work in Buckhead, and I drive an hour and 40 minutes to work in the morning, or an hour and 30 minutes to work every morning, and the same coming home if I'm not working from home. So instead of pushing them all the way to Atlanta, I wanted to still give Mr. Murray access for Selah when that time was necessary for him to pick up and drop off. But again, Your Honor, he declined to assist with any pickup and drop off during the week.
Okay. All right. Final ask, Ms. Waters.
Yes, I do have a couple of questions. Ms. Murray, when did you withdraw Changes Children's Schools?
At the time of moving out. So around either the last week of November to actually the first week of December, around that time, because I moved out December 1st to be exact.
Isn't it true that the children was still going to the current school until this school year?
Yes, Woodridge Elementary. They were actually going to school all the way up until April.
Okay. And so the 5-year-old was not in pre-K at that time. She was in regular, what type of school was she in?
She was at Woodridge Elementary at that time. I had them finish out the school year. It was best for them to continue throughout instead of transferring to a different school to interrupt their school schedule. So they were still going to Woodridge, and she was in pre-K at that time.
Okay. And so is she in pre-K right now, or is she in kindergarten?
Kindergarten currently for the new school year.
Okay. And so at the time that you made the decision to take the children out, or take the child out of Woodridge Elementary School, did you have a discussion with Mr. Murray that you would be doing that?
No, but he was aware of my moving previously, before they were going to a different school. He knew exactly where I was moving to. And
let me ask you this question. Did you discuss with Mr. Murray that you was changing the child's school from Woodruff?
No.
That's the question I'm asking. And so then you made the decision to change the child's school, and then you took her to the school in Conyers. And when you registered at that school, did you let Mr. Murray know that you were registering her in a different school?
I wasn't sure of the requirements to get them registered into the new school. So the process actually took a much longer time than necessary. I had to tour the school and things of that nature. So in terms of registration, that wasn't completed until the year of August, which is this year for the new school year. So no, I did not let him know previously until registration was complete.
And so prior to your registering the children for school in Conyers, Mr. Murray was picking the children up from school and helping out with getting the kids to school when they were still going to Woodruff. Is that correct?
No, he declined offering picking up the kids after school. I was driving from Buckhead and still picking them up from Woodridge Elementary towards the latter end of the school year, which was, I would say, February, March, April. Sporadically, he would go and pick them up during the week, but I would have them in aftercare program day after day at Woodridge Elementary, and I've had to pick them up on multiple occasions.
Okay.
And the school is
questions.
Are you telling me from February, March, and April, before the children were taken and placed in the Rockdale County school system, Mr. Murray would not help pick them up from after school?
Yes, Your Honor. They were at Woodridge Elementary until the last day of school, I believe was in May. He was not picking them up from school, and I can get a copy of their aftercare. He was not picking them up after school. I would have to ask him to pick them up from school, or maybe try to set up some time with him to see if he can pick them up from school. He would not. I would have to pay aftercare fee on multiple occasions from Woodridge.
And what did he tell you was the reason why he would not?
None, Your Honor. None. No explanation. And the school is only 2 minutes away from the home.
Okay. And let me go back to Mr. Murray. Mr. Murray, her position is that February, March, April, May, you were not picking the children up after school.
Your Honor, she has had the kids in aftercare, in which I pay half the aftercare fees. So at that point, there was no need for me to pick the kids up when she put them in aftercare. And I still have evidence, Your Honor, of days when I pick her up and she comes to pick them up from me in the afternoon. So at the end of the day, she's just there talking a lot of lies, Your Honor, because my daughter is my main concern, and she knows that. She knows that I love my daughter.
Mr. Murray, I'm not asking about the love you have for your daughter. I'm asking you about whether or not in February, March, April, and May, if you left work to pick your kids up from school early.
I pick her up whenever, Your Honor, whenever she's not in daycare. But when she is in daycare, I do not pick her up, Your Honor.
And what's the call as to whether she's in daycare or not?
When her mother tells me that she'll be in daycare, and I go to the school every Friday when and I pay my part of the daycare fee on Fridays when I go pick my daughter up from school. So whenever she's in daycare, I do not pick her up. Whenever she's not, I go and pick her up, Your Honor.
Okay, you do recognize that's not what you told me, right?
You said what?
You do recognize that's not what you told me earlier. you told me earlier that for the year you were doing this, and that the only time you did not do it was when mom was told.
Your Honor, I'm sorry. That was when what I told you is when she was living here, not when she moved out, Your Honor. That's what I was talking about. I'm sorry if you didn't understand that. But that's when they were living here.
Okay. I guess what I'm asking is, why is there a difference? If she was living at your house and you were able to get her, why, when she left, what made the change? What made you decide to not pick them up?
As I said, Your Honor, I pick her up on the days when she's not in daycare. When she's in daycare, I do not pick her up, Your Honor, because it makes sense for me to pick her up when she's paying for daycare.
Ms. Murray, when did you decide to do daycare, and when did you decide to ask Mr. Murray to pick the child up?
Your Honor, I do have two girls, one that's 10 and another that's 5. And with my oldest daughter, it was an issue for him to pick her up and my youngest. So I have my oldest in the aftercare program. Again, we were a family at once, and he decided that picking her up after school is not what he wanted to do. And that includes my child. And his mom had to intervene and say, okay, they're still sisters and you need to pick both of them up after school. So it wasn't a decision for me to pay for aftercare, because her dad literally lives 2 minutes away from the school. So it would be best for my child to be home with her father at that time, to then eat dinner, change out of school clothes, and do homework. And then I would pick them up and take them home. But again, Your Honor, Mr. Murray declined and then initiated to pay the aftercare fee because it was suitable for him.
Okay, thank you. All right, then. Any final remarks, Ms. Waters, Mr. Singleton?
No, yeah.
All right, then. So what we're going to do is, I don't think we need a guardian ad litem. I will ask the children those questions. I think at the time we can also speak with Miss Anna Lewis as well. So I don't think it's necessary to spend money on a guardian ad litem. Also, with regard to temporary solution, we'll do from Thursday to Sunday. Thursday to Sunday, was that every Thursday and Sunday, or was that every other?
We were asking for every Thursday through Sunday.
Every?
Correct.
Okay, and Ms. Murray, how do you feel about every weekend? Generally, I don't like one parent to have every weekend, but for temporary purposes, I don't mind doing it for temporary. But I can tell you that's likely something I'm not going to continue to do.
No, we're asking on a temporary basis, Your Honor.
I could do it for a temporary basis, but when we start looking at it, I don't like to have one parent have all the weekends. That's just not fair to the other parent as well. So
yes, Your Honor. May I object? I do suggest that Selah is in my care Friday mornings, especially when she's going to school, making sure that she's properly dressed, her hair is combed like it should, and she goes over her sight words prior to testing every Friday. Mr. Murray, again, did agree to have her Friday, Saturday, and Sunday. So if we can continue with that temporarily for Friday, Saturday, and Sunday, I would be happy with that, Your Honor.
Okay, so why not Thursday after school? Why can't he manage Friday?
Again, if he can, make sure that her hair is properly combed and she studies her sight words for Friday, because she do get tested weekly on those, and it's paramount that she studies. I would have to consistently remind him that he do that with her when he's with her on the weekend. But that's my only concern.
We're gonna give him Thursday to Sunday. Watch the grades and watch how she comes to school. If there's an issue, take it up. I suggest, Mr. Murray, that you make sure the kid is prepared for school physically, as well as making sure her sight words, and we'll just look at those when we cross that bridge. But for right now, I'm going to grant access the Thursday return.
Your Honor, can I say something? Her mother does not allow anyone to comb her hair. I would have my aunt or my cousin comb her hair, but her mother does not want anybody else to comb her hair except for her. So unless she agrees on that part where I can have my aunt combing her hair, then that would be okay with me.
All right, Ms. Barrie?
No, I decline. If you see my daughter's hair, it's very delicate. The slight pull, she get baby hair bumps and really dry tensions in her hair. So I always have to comb her hair because of the pain that she feels when anyone tugs or pull on her hair, and it shows irritation to her scalp and things of that nature.
Okay, so you're telling him to keep the child's hair up without any alternatives. What do you expect him to do?
Yes, yes.
What's the alternative?
No one combing her hair while he has her.
I suggest that you send Mr. Murray a note on what you need for him to do to keep her hair. If you want it to look good, but you don't want anyone to touch it, you might want to ask him to wrap it or whatever you want him to do. I suggest you send him a note on it. Otherwise, if he can't touch her hair, it's going to be hard for him to keep it up unless you have some suggestions on how that's going to be done. All right.
I do, Your Honor. Thank you.
All right. Good. So, Ms. Waters, if you have prepared order for the court denying the motion for guardian ad litem, granting the request for temporary support, we will give Mr. Murray support, for custody on every Thursday, return on Sunday. But like I said, that is temporary. When we have the full hearing, it will not be every weekend. That's for certain. Okay. All right. Thank you, Ms. Slaub. Is it Salad?
Salb.
Salb. No.
Thank you, Judge. May it please the court. This has been a long and extremely troubled, nearly 20-year marriage with some very disturbing behavior that's been committed numerous times over the years by Mr. Anderton. But fortunately, Your Honor, the issues are few, they're simple, and they're straightforward. My client is Michelle Elliott, and she is 51 years old. Mr. Anderton is 49 years old. He is about to be 50. My client works for a transportation service. Mr. Anderton works as a truck driver. The parties were married on May 11th, 2004 in Charlotte, North Carolina. And they've been together for quite a while before that because they have a daughter, Mia, who is 21 years old. And then they do have a minor child, Maya, whose parties, evidence is going to show, the parties have lived separately for about 15 years. But they would interact from time to time, attempt to date, I guess, for lack of a better word, but they have not shared a residence during that time. Now, it's been a kind of an unusual situation because even though they've remained married, my client, but they were living separately, my client had to go and get child support enforcement, get an order of child support for the two daughters in 2018. And so that order has been in place since that time. The current amount is $1,025, and they have tacked on a $50 additional amount towards the arrearage. Now that arrearage is up to $29,000, and that is the main issue that we're going to be focusing on today. And I will circle back around to that in just a minute and how that relates to what we're going to ask the court to do. Now, one of the really unusual facts of this case is that my client lived for many years in a home that was owned by Mr. Anderton and his mother. And that residence was in Gwinnett County. And even though my client was not on the deed or on the mortgage, it was purchased after the marriage by Mr. Anderton and his mother. So she did have an equitable interest in that house. Now, as I stated, Mr. Anderton did not live there, but that residence was provided for my client and the girls to live there. Back in May of 2022, there was an altercation where Mr. Anderton was violent with my client. He also had an order of protection, a criminal order of protection that was taken out by his mistress in Henry County. So he was subject to those conditions as well. Mr. Anderton violated his probation with the Henry County case by appearing at the Lawrenceville address in October of 2022 and violated the terms of that probation by violently kicking in the door and threatening my client. The children were present and witnessed it. It was very disturbing. He was out of control, intoxicated, yelling and cussing at the children. It was a very bad situation. He was arrested and he was his probation was revoked, and so he was incarcerated back in Henry County. Well, in the meantime, at the end of 2022, early part of this year, out of revenge, Mr. Anderton had his mother evict my client out of the Yuba Walk property, which unfortunately, legally, she could do that. Whether it was a morally supported, that is definitely up for debate, but legally she was allowed to do that. And so my client had to scramble and find a new place to live. It was a very bad situation for her. And I should add too, as the court is probably aware from the amount of the arrearage, Mr. Anderton has been paying very little on his child support. And so it has been extremely tough on my client to be able to make ends meet. When he got out of jail, and I believe it might have been in June, he started contacting my client again. And at that time, the property was sold, and evidence is going to show that Mr. Anderton, to rub my client's face in it, sent her pictures of a car that he bought, a picture of himself in new clothes, and it appears that he's in some kind of room that looks like it's remodeled, bragging about the fact that he has this money and, he's gotten out of jail, and, sending her harassing texts about there's nothing she can do about any of this. And so my client, had enough. And so she has filed for divorce. I want to add on the child support arrearage. Mr. Anderton did pay the sum of about $3,000 back in the fall. And we believe the reason he did that was because his license was going to be suspended. And from what I can tell, he has done that a few times. He'll pay just enough to get it out of suspension, but it really doesn't make a dent in anything because he's not paying currently, or he's paying like here and there, and the arrearage just keeps growing. But I did want the court to be aware that he did pay that lump sum back in the fall. Child support enforcement also required Mr. Anderton to take a fatherhood program, which he ignored. And they informed my client that he failed to take that as one of their requirements. And so, Your Honor, my client's issues for today are, well, and this should be a very easy one. We asked that the court grant the divorce. It is definitely irretrievably broken. My client would like her maiden name of Charisse back. We are asking that the court grant sole legal and physical custody of Maya to Miss Elliott for several reasons. She has been the sole custodian of her daughter. The last contact that Maya has had with her dad was when she witnessed him trying to break into the house in October of 2022. It was very traumatic for her. She's scared of her father. We have filed a proposed parenting order with the court that grants sole legal and physical custody to Miss Elliott. Now, if the child decides she wants to visit with her father and she's at a time where she's not afraid, then she should be allowed to do so. But we're asking that the court not force any visitation at this time. And also, too, because he's shown no interest in her. So forcing her to visit under these circumstances, we think would not be beneficial to the child. As I stated, the child support is already established through child support enforcement. I do want to make the court aware that Mr. Anderton has applied for a review, and I think that might be because he might want to be removing the oldest child from the obligation, which is appropriate because she is no longer a minor. But I did want the court to be aware of that because they do have that scheduled. And so that is something that this court would not need to address today. So, Your Honor, what that leaves us with is this arrearage, which is definitely owed to my client. What we're proposing is the court address it this way. Evidence is going to show that the house was sold. Mr. Anderson has told my client that it was sold for $155,000. So he and his mom presumably have, at least in theory, divided that amount between themselves. He owes $29,000 in child support. So we're asking that the court order Mr. Anderson to pay my client $77,500 because that is marital funds. And of course, representative in that sum is the $29,000 of arrearage that my client's just not going to get any other way. And evidence will prove that Mr. Anderson is very capable of working. He has lots of nice material things that he's, of course, making my client aware of. And he can get any funds that he needs. His mother is always there to bail him out. So that is not or should not be an issue for him. So that's what we're asking the court to do, Your Honor. We're also asking the court to order Mr. Anderson to pay Miss Elliott her attorney's fees of $5,000. And I would also ask the court, I think this is an appropriate case for an ongoing restraining order. So we would ask the court to make that a part of the final judgment as well.
All right, thank you. Mr. Anderson.
Yes, good morning, Your Honor. Good morning, Mr. Saab. Thank you in advance for providing that information to me via email this weekend. Your Honor, I've had time to listen to the plaintiff's introduction, and I would just like to rebut many of the statements that Ms. Elliott's attorney made. First and foremost, myself and Ms. Elliott, we started to become a couple in 1997. We did get married in 2004 in Charlotte, North Carolina. We moved down to Stone Mountain, Georgia in 2005 with myself, my wife, my two stepkids, and my 21-year-old. My mother moved to Lithonia, Georgia in 2006. She purchased a family home. We all lived in the house as family. Due to circumstances of people not getting along, my mother had bought a townhouse in Lawrenceville, Georgia. My wife decided it was best that we relocate out there because of the tension between her and my mom. I was a resident in Lawrenceville, Georgia, technically up until 2020. So where Ms. Saab says that 15 years that me and Ms. Elliott were not an item, that's totally inaccurate. In 2018, we had, I say, our first initial separation. And that was noted on the first disposition that was sent to the Henry County Jail that I received in February of 2023. In this new parenting plan order, it shows that we haven't been a couple since, 2022. So there's a discrepancy with that as well. During 2018 and 2022, we had a separation until 2020. I moved back into the home in Lawrenceville up until 2022. I didn't have time to provide exhibits because I didn't know that this court date was coming so soon. But like with anything, I do have photos that show myself, Miss Elliott together on her birthday, her, 50th birthday maybe? 49th birthday. Also photos of me with my 12-year-old. My 12-year-old resided with me here in Lithonia, Georgia in 2020 during the pandemic. Ms. Elliott voluntarily gave her to me from August of 2020 until I would say shortly after Thanksgiving of 2020. So that rebuffs the fact that we haven't been together, we haven't had a relationship, and to say that my child is scared of me, my two daughters that I had with Miss Elliott, they were always with me, have always been with me, and there's other people that can confirm that. To this day, I'm still in contact with Maya's teachers at her middle school, and because I still get the progress reports, and I've advised her. Although haven't been able to see Maya, I'm still very much concerned about her educational well-being. So I do have communication with her teachers. In addition to that, Ms. Saab has mentioned that she is seeking $77,000 with 29 going to Ms. Elliott. My mom, Ms. Eloise Anderson, she purchased both properties. I had no financial investment or interest in buying these properties. They were solely purchased by my mother, Ms. Eloise P. Anderson, and it can show that in court records. In 2022, after not being able to see my daughter for about 6 months, I had an emotional issue. I would say probably a mental breakdown. I was going through a lot, but the primary thing was I was being involuntarily held from seeing my daughter. I reached out to Ms. Elliott on several occasions. She never responded. So I did kind of take actions into my own hands by going over there that night because I wanted to talk to her foremost, but I wanted to see my daughter as well, who I raised. So despite what the accusation is on the police report, and I plan on doing my best to rebuff that, the door was never kicked in. The door was pushed in. The frame of the door had already had pre-existing issues. And if somebody wanted to apply pressure to that frame, it was easily accessible. I shouldn't have done that, but I did it going off an emotional thing. Ms. Elliott did not have a current restraining order at me on the time as Ms. Saab stated. There was no existing restraining order. I did have the issue in Henry County, but the Henry County issue only came up because I had police contact with Lawrenceville. And because of that, that was a technicality, and I did violate my probation, where I served from December 13, 2022 until June 11, 2023. When I got out, I attempted to reach Ms. Elliott, no contact at all, no response. There might have been maybe an email or two where she responded, but I had 2 to 3 phone communications with Ms. Elliott, and maybe she didn't advise Ms. Saab of. All right. The very last communication was in October of this year. My daughter Maya, she turned 12 November the 12th, and I asked Ms. Elliott verbatim, "Can I see my daughter?" Her response, in quotes, "I'll think about it. I don't want her seeing your mother. I'm mad at your mother for selling the house and putting us on the streets." Okay. November 12th came. I called, left a voicemail, wished her a happy birthday. Voluntarily, I submitted money into child support so that she could have a nice birthday, knowing that I wasn't going to see my daughter. But I still did that anyway. So at some point, I would like for Ms. Saab to ask her client why she is involuntarily keeping my daughter away from speaking to me. It's not because she's scared. It's because she's been modern day coached. I would like mediation, and I'm going to request it also, because I would like Maya to be able to talk to someone in the courts that's a mediator. And I would like Maya to express herself on whether or not she wants to continue to have a relationship with her father, not only her father, but her grandmother, who's 85 and doesn't have many years on this earth, but loves her to death. And I think then we could get a clearer understanding of how far that fear goes. In addition to that, any information regarding the issue with my mother's property in Lawrenceville, they were handled by Clark in Washington. My mother was going through a bankruptcy. Sandalwood Townhomes, they were attempting to repossess my mother's property due to back taxes. That is the reason why the house had to be sold, and it was sold in order to save some of my mother's investments. Never once did I advise Ms. Elliott that the property sold for $155. Absolutely incorrect. We barely had communication, so I would not even disclose a number to her, especially a number that was false, that could put me in a situation like I'm in today. The fatherhood program. Of course, the fatherhood program is offered to mothers or fathers who are currently in back child support, and it offers us an opportunity to get into programs and things alike. I was in the program. Due to a work assignment, I was 15 minutes late for a phone call. Because being 15 minutes late to that phone call, I was automatically disqualified from the program. Not for lack of interest, not for wanting to be in the fatherhood program, because I did find a couple of programs that I think would be to my advantage. They automatically disqualify people to lower the class amount. So there was never a time where I was negligent in attending the fatherhood program. Never have I been negligent with the taking care of my two kids, my two daughters that I have with Miss Elliott. Miss Elliott is present. We've had domestic issues, yes. We've had fights, yes. But during times like this, it's always so easy to bring out the negative stuff. It's been since 1997. A list of all the good things would be nice as well. I know it's not beneficial in their case, but it would help me out tremendously. I might not have been the best father, best husband, but I was a tremendous father, and I am. And I continue to look forward to being in my daughter's life, to raise her. I miss her dearly. And I would ask the court for some type of mediation to allow Maya to speak on those terms. She's 12 now. Let her grant her wishes on what she wants. Does she want to live a life with just her mama and her sisters? Or does she also want to live a life with the man that has been with her since her birth?
All right, thank you. Ms. South, call your first witness.
All right. I call Michelle Elliott. Were you a resident of the state of Georgia at the time you filed for divorce?
Yes.
And your husband was incarcerated in Henry County at the time you filed for this action, is that correct?
Yes.
But his address was in Lithonia, DeKalb County, is that correct?
Yes.
And he was personally served with a copy of this summons and complaint in Henry County Jail, is that correct?
Yes.
And you were married to him on or about May 11th, 2004 in Charlotte, North Carolina, is that correct?
Yes.
And you have lived separately from your husband for quite some time, is that correct?
Yes.
And what was the date of last separation from Mr. Anderton?
May 2023. 2022. Sorry.
And have you remained in a bona fide state of separation from him since that time?
Yes.
Okay. And you have two daughters with Mr. Anderton, Mia, who is 21, and Maya, who is 12.
Yes.
And you are not currently pregnant?
No.
And is it your testimony that this marriage is irretrievably broken with no hope of reconciliation whatsoever?
Yes.
Okay. And you are asking the court to grant a total divorce in this case?
Yes.
Okay. Miss Elliott, what is your highest level of education?
I have a GED.
And you heard Mr. Anderton testify that you've been together since 1997. Is that accurate?
Yes.
How did you meet him?
In a nightclub in 1997. Yes, met in a nightclub.
And you started dating after you met him?
Yes.
And was that in North Carolina or was that in Georgia?
In Connecticut.
Oh, neither. Okay. And so did you move in with him after some period of dating?
No, he moved in with me. He was living with his mom in the Bronx, New York, and he moved in with me.
Okay. And approximately when did you start residing together with him?
About a year later.
So around 1998?
98, yes.
Okay. And then you had your first daughter with him, is that correct?
Yes.
And what year was that?
July 26, 2002.
And where were you living at that time?
Bridgeport, Connecticut.
And then you married him.
Yes.
You married him in 2004?
2004.
And where did you get married?
We went to visit his mom in Charlotte, North Carolina. It was May 11, 2004.
And so you had your one daughter together by that time, is that correct?
Yes.
And were you still living in Connecticut at the time you got married?
Yes, we were.
Miss Elliott, what were you doing for work at the time that you got married?
I'm a professional bus driver for transit, Bridgeport Transit at the time, CDL.
Okay. And about how much were you making at the time you got married?
About $28,000.
And what was your husband doing for work at the time you got married?
Unemployed.
Was he working when you met him?
No.
Was he doing any work between the time you met him and the time you got married?
He was working in the street.
What do you mean by working on the street?
A drug dealer.
How long did he do that?
Say about a year. And I had him get a job, go back to school and get a job.
Did he get a degree while you were together?
He did training. He did computer training. He was working with computers. Business, office.
Oh, I'm sorry, I didn't mean to cut you off.
Working in office, he was doing computers.
Okay. So was he doing IT work or maintenance?
Something like that, yeah.
And so he got a job doing legal things, is that correct?
Yes.
Legitimate work.
Yes.
And do you remember how much he was making when he started doing legitimate work?
About $25,000. Then eventually he moved to Georgia. We moved to Georgia and he ended up getting his CDL like I do and started driving buses and became a supervisor.
So you all were working in the same field, is that correct?
Yes, yes. He followed behind me to get his CDL.
Okay. When you moved to Georgia, were you making similar incomes?
No, we took a pay cut because Georgia's a little cheaper. So it was a pay cut. I ended up driving a school bus for Gwinnett County. Mr. Anderson was working odd jobs.
But as far as your incomes, were they similar, doing the same type of over-the-road driving?
Somewhat similar. But he was making a little bit more than me. He became a supervisor.
Has he remained in that line of work throughout the marriage?
Yes. And then eventually he got laid off in 2020 and ended up getting a contract with the government with the refugees, driving a CDL bus, making almost $2,000-3,000 a week.
So, Miss Elliott, when you had your children, were you responsible for their child care?
Yes. We both were. He was helping out too, but mainly it was me because he started working overnight.
And at some point, is it fair to say that you started to experience problems in your marriage?
Yes. When Mr. Anderson started working at American Coach, he became the supervisor, and he had multiple.
Miss Elliott.
Miss
Elliott. I couldn't hear you. You said he started working with Coach.
Hello. Yes. I said yes. American Coach. Yes, he started working with American Coach. And when he worked his way up and became a supervisor from a driver, and he started messing with multiple women at his job, have years of affairs with many of his his coworkers that he worked with. One of them in which he moved in with.
How were you aware that he was engaging in adulterous affairs?
Because he was driving her car. One time at my daughter's basketball game, he was driving her car, and she called him and told him to meet her at the mailbox. And she called several times. I saw several text messages. And when I went to the job, I didn't know that she worked in the office with him, dispatching, for many years. Then he ended up moving in with her.
And what was this woman's name?
Alethea Mays.
And what year was this?
Oh, and he moved in with her in 2018, but he was dealing with her 6 years before that. They had a long relationship.
Were there any other problems that you had in the marriage besides the adultery?
Yes, his drinking and cheating, violence, just everything. It's been very hard for me.
And so from your testimony, are you saying that these problems started around the time that he was hired by Coach?
No, some years before that, but I just put up with it when he was working at another job, and then he started working there. I put up with it, just kept taking him back. He kept telling me I'm crazy, I'm making things up, and I would take him back because of the kids, because, you know, I needed help with the kids and somewhere to live. And then he would be fine for a few months, and then a few months he'll come and just destroy everything and fighting me. It's just been ongoing for 25 years, and I just finally had enough when I saw him in a car with the lady, another lady that he worked with, who's also friends with his mother.
You heard Mr. Anderton in his opening statement describe what he's telling the court is where the two of you have lived together and when. Is that accurate?
We lived together, but his mother and him tag teamed me and arguing with me, fighting me. He's fighting me, and his mother blames me for him fighting on me. He goes to her and she bails him out. I'll get him arrested, and she'll go and bail him out and blame me for, you know, everything that he done to me. And I just had enough. Fighting me in front of the kids, my oldest two kids. My kids are traumatized.
Okay, well, I'm going to ask you something about the residences in just a minute here. I am going to try to share the screen here and show you what's marked. Let's see. Your Honor, are you able to enable the screen share, identify this document?
That's my computer that Mr. Anderton smashed and broke up.
Okay, when did that occur?
On Yuba Walk.
When did it occur?
Oh, May 2023. I mean 2022.
Okay. And is this picture accurately displaying what's shown therein?
Yes.
Okay. Your Honor, we tender Plaintiff's Exhibit 1.
I'm Plaintiff's Exhibit 1, so admitted.
And Miss Elliott, I'm going to also show you what's marked as Plaintiff's Exhibit 2. Can you identify that document?
That's me, Mr. Anderton, bust my lip.
And when did this occur?
May 2022.
Can you identify this document?
Yes, that's me. He's scratching my neck.
And when did this occur?
May 2023. I mean 2022. I'm sorry. The same day as he did my lip.
And does this picture accurately portray what's being shown?
Yes. That's
Can you identify this document?
That's 223 Yuba Walk in Lawrenceville. Mr. Anderton kicked the door in.
And when did that occur?
2022, May.
Can you identify this document?
Yes. That's Mr. Anderton's paperwork from Henry County.
From which county?
Henry County. No, Gwinnett County. Gwinnett County. That's when he, yeah. I'm sorry, I can't see too good. Yes, when he attacked me when the kids were around.
And that was what year?
So much stuff happened. 2021. Yeah, 2021. So much stuff happened over the years. So many dates. Yeah.
It's the docketing date, the 19th, 2019.
Yeah, probably. So much incidents happen.
And you were involved as a witness, as well as a victim in this case?
I'm the victim. I'm the victim, and my kids were the witness.
And this is an accurate copy of the paperwork from Gwinnett County regarding this incident?
Yes.
Your Honor, we tender Plaintiff's Exhibit 6. Miss Elliott, you said that Mr. Anderton had a problem with being unfaithful.
Yes.
Correct. And you said that there was an incident in Henry County. Can you tell the court what you know about that situation?
He texted me one day sending me a picture of his foot being broken. And I asked him what happened to his foot. And he said, somebody ran into him and his foot got stuck under the pedal. But I didn't believe that. So I was like, I went and did some investigation. And I went to Henry County to get the police report. And I seen on there that he was in an altercation with Arlethea Mays, his girlfriend, and her kids. And I guess she ran over his foot and broke his foot. So he was in a cast for almost a year. And when I found out the information, he tried to tell me another lie, which I knew I already know. I already got the police report. So then prior to that, 2 years later, he went on Mother's Day and an Uber went over there with knives and went over there fighting her on her Mother's Day, and her two kids, her two sons jumped on him and broke, as you can see, he's missing his tooth in the front. They knocked his tooth out and broke his eye socket and scars on his forehead. And he tried to call me from jail telling me another story, but I got the police report on that, stating that he was over there fighting her. And that's when he went to jail for Arlethea Mays, his mistress.
All right, Miss Elliott, I'm going to show you what's marked as Plaintiff's Exhibit 5.
Yes, that's when Edward, I guess he pleaded with Arlethea Mays and her two sons for going over there with a knife and fighting on Mother's Day.
And this is an accurate document that you got from Henry County?
Yes.
Your Honor, we tender Plaintiff's Exhibit 5. Can you identify this document?
That's Mr. Anderton and his other girlfriend. I don't know her last name, but her name is Lulu, which is his mother's friend too. She picked him up at the gas station near my house off Yuba Walk in Lawrenceville. And I caught him and took a picture.
You took this picture?
Yes.
And does this picture accurately portray what's being shown?
Yes.
Miss Elliott, let me ask you about the residences and where you and Mr. Anderton have lived within respect to one another. So you moved to Georgia from North Carolina when?
From Connecticut in March 2005.
I'm sorry, I've got North Carolina on the brain because I'm a Charlotte native, probably. So you moved, where did you move to in Georgia when you moved from Connecticut?
We moved to Stone Mountain, my nephew's brother's house.
And
I was renting.
How long did you live in Stone Mountain?
Say about a good year. About a year or two, yeah.
You heard Mr. Anderton testify that his mother got a house for you all to live in because you and she didn't get along. Is that correct?
Well, no, that's not true. He cheated. He was cheating and fighting me in front of the kids. Wasn't coming home. He worked one weekend and told me he was on his way home, and he didn't come home until that Monday. And we got into a very bad fight. And his mother was helping him, taking phone calls from his other girlfriend, helping him cheat. Then she would argue with me all the time, put me down, and, just too much in front of my kids. So they advised me to move to Yuba Walk with the kids that they owned.
Who advised you to move to Yuba Walk?
Mr. Anderton and Eloise, his mother, Eloise Anderton.
Now
I lived there for 7.
I'm sorry, go ahead.
Excuse me?
I didn't mean to interrupt.
I lived there for, I moved from Lithonia, from the family house. Excuse me?
Sorry, Judge.
How long did you live at the second address?
Ubawalk, 17 years.
How do you spell that last name? The name of the road, street?
Y-U-B-A.
Walk, W-A-L-K.
And is that in DeKalb?
No, Gwinnett County.
That's Gwinnett.
Okay.
So, Miss Elliott, when you moved to Ubawalk, did the children move there with you?
At the time, I only had 3 kids. Maya wasn't born there yet. I moved there with 3 kids. But my son eventually, because so much fighting, my son moved back to Connecticut with his grandparents.
So when
I was just left Ocoya, which is, I moved to Ubawalk. I moved to Ubawalk with 3 kids, but my son ended up going to Connecticut because it was too much violence and he couldn't be around Mr. Anderton no more for him hitting on his mom. And my daughter Mokoya moved in with me, but she eventually went to Georgia State and stayed on campus. But we're just stuck with this Mia Anderton. And then a few years later, I had Maya.
Now, you heard Mr. Anderton testify. Well, I can't say he testified because he said it in opening statements, but he stated that he did not live at Ubawalk. Or I'm sorry, he did live at Ubawalk. Is that correct?
He was on and off. Whenever he gets a girlfriend or he want to get out the house or leave, he'll go live with his mom. And since his name is on the deed and the title, he was able to come back and forth and have residence at both places.
His name is on what deed?
Of Ubawalk. His name is on the deed and the title with his mother.
Now, you heard him state that his name was not on the deed. Is
yes,
that
it is
accurate?
His name is on the deed and the title, and he was also able to take bankruptcy out on Ubawalk. Him and his mother. Well, they did it separate.
Mr. Anderton filed for bankruptcy?
Yes.
Excuse me, Your Honor?
Yes.
I can't hear through the noise.
What noise?
No, it was multiple conversations going on. I didn't hear you. I'm sorry. What was your question?
My question to Ms. Elliott was, did Mr. Anderton file for bankruptcy?
And the answer?
No, I wasn't asking you. I'm asking her.
Okay.
Yes, he did.
And we filed for bankruptcy. You're saying he listed the Ubawalk residents?
Can you repeat that? I can't hear you. It went out.
No problem. Are you saying that when he filed for bankruptcy, he listed the Ubawalk residents?
Yes, ma'am. Yes, ma'am. Yes.
Okay. And that is the property that sold?
Yes.
Okay. When was that property purchased?
I'm not sure of the date. Let me see.
During the marriage or before the marriage?
During the marriage, yeah. During the marriage, yeah.
Okay.
And Mr. Anderson also had to sign for her in order. She took out a loan. In order for her to take out the loan on Ubawalk, he has to sign. In order for her to sell the house, Mr. Anderton also had to sign. So she waited till he got out of jail at Henry County so he could sign for them to sell it.
Okay.
And then
you know if Mr. Anderton paid monthly amounts?
Yes, he did.
He
paid the HOA fees because I've seen it, and he wrote out checks and money orders, and he paid the HOA fees. His name is down on everything. He paid the taxes. Yes.
All right, go ahead,
son. Towards that end, to dovetail with the judge's question, let's see, I am going to show you what's marked as Plaintiff's Exhibit 15. Can you identify this document?
Yes. That's
What's
Mr.
that?
Anderton and Miss. That's the deed and the title. Mr. Anderton and Miss Edward Anderton and Eloise Anderton. Yes.
Okay, and that is a true and accurate copy of the deed.
Yes.
Your Honor, we tender Plaintiff's Exhibit 15.
So
Miss Elliott, did there come a time because of the separation with you and Mr. Anderton that you sought the help of child support enforcement?
Yes. When I noticed Mr. Anderton was splurging with other women and paying Miss Arlethia's bills, taking her out to eat, and then me and my kids over there at home struggling, you know, hungry. He wasn't paying a cell phone bill. He just stopped doing a lot. So I asked him for money, you know, would go by his job and ask him. He would tell me no. So I had to take out child support.
And when did you go to them?
It was in 2018. I forgot the correct date. I think it's September 2018.
Can you identify this document?
Yes, that's the my child support order. Yeah, it was July. Yeah.
And this was an order of child support established for both of the daughters?
Yes.
Okay. And this is a true and accurate copy of the order that was issued by DeKalb County Court. Is that correct?
Yes. And he also didn't show up for that court proceeding.
And once that order was established, did Mr. Anderton abide by it?
No, he laughed at it. He said he's not paying nothing.
And have you made your best efforts to seek enforcement of this order?
Yes, I call almost every day, every other week, complaining because he works. They said since he's a 1099, they can't touch him. So he knows that. So he's his independent contractor. So it's like really hard to get money out of him, and he's sitting on money. Only time he wants to pay is they suspend his license, and he'll renew it, pay $50 on the website, and he'll renew it and get it back. Because that's his source of income, because he's a driver. He needs his license.
Miss Elliott, I'm going to show you what's marked as Plaintiff's Exhibit 9. Can you identify this document?
Yes, that's the child support order.
And this is updated as of November 29th, 2023?
Yes.
And that is his most recent arrearage, is that correct?
Yes.
Did he pay you a lump sum anytime recently?
Yeah, he paid $3,000. Well, he paid $23,000 and then another $7,000, which would be $3,000 in October.
And to the best of your knowledge, this is a true and accurate spreadsheet of his child support arrearage.
I got it off the website that they have us go through.
All right. Your Honor, we tender Plaintiff's Exhibit 9.
Plaintiff's 9 still.
Elliott, can you identify this document?
Yes. Mr. Anderton left his backpack at my house, and I went through it, and I seen that Mr. Anderton had left his pay stubs, that a debit card that they give him to drive as a driver, his information, and all the money that he makes, $2,000–$3,000 a week almost.
And what was the date on this document that you found?
I found it about a few months, like last year or sometime, yeah, before he went to prison. I mean, jail in Henry County.
Okay. And you have not altered this document in any way?
No, that's a copy from the job that he works at that they gave him. Like, it's pay stubs, basically, all the printout of the money, where he spends all his money and how much money he gets.
And to the best of your knowledge, this isn't accurate reflection of his pay in May of 2022?
Yes, that's how much he gets. Yeah.
Your Honor, we tendered Plaintiff's Exhibit 10.
And he still works there too. He still works there. He still travels and works there.
And is he so admitted?
But since he's a 1099, child support they can't touch that, they said, because he's an independent contractor.
Miss Elliott, can you explain what happened in May of 2022?
I don't even like bringing it up, but I got home from work and Mr. Anderton was drinking heavily, like he always do. And he started accusing me of cheating. And then he wanted to fight. My daughter, Maya, was in the bed asleep. And he slapped me in the back of my head very hard. And I have high blood pressure. He slapped me in the back of my head really hard. So we started tussling. And I was trying to call the police. He made sure I didn't call the police. He threw my phone under the bed. So he got on top of me and started choking me. And eventually he ended up getting off of me. And I ran down the stairs. And he ended up falling down the stairs, which he told the police that I pushed him and hit him. So I eventually got outside, me and Maya, and we get in the car. And he's had my keys, so I couldn't leave. So eventually he noticed I was going to call the police, tried to call the police. And he ended up taking my computer and smashing it. I don't know. It's just so much.
Was he arrested that day?
No, because he had scratches on him. They said it was going to take both of us. And it was the last day of school, and my daughter wanted to go to school that last day so bad to stay by to her friends for the summer. And she eventually didn't go. And Mr. Anderson, they told me they was going to arrest me. We have so much police calls there so much that it's becoming a nuisance. And I didn't get arrested. I just went downtown to my daughter's dorm room, and I stayed for a couple of days. And Mr. Anderson stayed at the house. But when I ended up coming back, I went to a neighbor's house and waited because I knew he had to go to the doctor. So I waited. So I ended up seeing where he was going. I saw him going across the street to the gas station, and I waited a few more minutes so I could clear and go to the house. But as I seen him waiting, I know he didn't have a card in. I thought he was taking an Uber, but it was the lady. He was in the car with Lulu. And I ended up
picture that you took.
Yes, I ended up snapping the picture. And I said to myself, this is the second time I call him with this lady and phone calls and stuff. And I told him, please don't let nobody come by the house. I know you cheat all the time, so just don't have nobody come by the house. Please respect the house and the kids. But he didn't. So I ended up going in the house, crying and very upset. So he kept calling me, telling me that he was going to pick up a new car. We need to go for a ride. She just gave him a ride. But I knew at this point, I was about to turn 50 years old and we were supposed to go on a trip. But I know every time my birthday come up, he do something to ruin it. And I just knew I didn't want to be a 50-year-old woman just had a grandbaby still fighting in front of my kids. And the neighbors, they were so sick of me and him. And it's not me. I'm a battered woman, you know.
So this incident in May, I'm sorry.
Yes. I finally got out. I finally got the strength to leave him. I'm sorry.
And this incident in May of 2022, that's when you consider that you separated for the final time.
Yes. And then he pops up in October, kicking in the door, cussing out my daughter.
Yeah, tell the court what happened in October of 2022.
I kept getting a strange phone number popping up. I guess he used Google numbers, and he kept calling me. I was in there watching TV, music, and my daughter, Mia, went to dance class because she go to dance class, you know, because her father, you know, she go through a lot with him, so she started taking up dance. So she went to dance class, so my car wasn't outside, and then we had it dark inside, and my daughter had a friend over that night. And someone just kept calling me from this number, and I wouldn't answer. And he left a voicemail saying, she ain't effing answering. So I still didn't notice nothing. So eventually he ended up coming ringing the doorbell so many times. And I'm like, what do you want? What do you want? And he was like, I want to see my daughter, but Mr. Anderson don't want to see his daughter. He comes at nighttime drunk. He never calls in the day. He never calls me, email me in the day. He always call at night when he's drunk. And I'm like, how Lawrenceville police didn't see him driving through from Lithonia to Lawrenceville drunk. So he comes over there and then he's ringing the bell. So then eventually Mia pulls up in the car and she's trying to talk to him and tell him what he's doing, why he over here. And he's calling her all kind of B words. You know, who talks to their daughter like that? B words, and kicked down the pumpkins off the porch. And then eventually he got upset and he ended up kicking the door in. And I went and sat down because I know I don't want to engage with him, because if I engage with him, he's going to blame me again. And then this time I think they really was going to take my kids, my daughter, because it's been too much incidents. So just so happened the lady next door, Maya, ran with her friend to the neighbor's house. And the lady next door, which is on the HOA board, happened to be staying next door. And she came out and she was telling Mr. Anderson, why are you doing this? What are you doing? Why are you coming over here doing this? And he told her, this is my house. I pay taxes and property on it, which I videotaped it. And eventually when the police came, he called his mother. I called her too. And I said, you know, Mr. Anderson is over here being violent and, you know, cursing and stuff. And she's like, what did you do to him? And I'm like, I didn't do anything to him. She said, well, he's been drinking all day. I said, well, if he was drinking all day, why did you take his keys? You know, why did you let him come over here doing this? We peaceful now. And she was like, well, it's his house. He could do what he want. So I was like, oh, whatever. So the neighbors and all the neighbors called the police. So when they came, they saw a lady cop, which was a little small lady, and an older gentleman cop. So when they came in and saw that the door was kicked in and he broke a mirror, like a glass mirror, they said, he did that today? I said, yes, he did that today. And they went outside and said, we're going to arrest you. And he ended up fighting the police. So I came out with the video camera. So, you know, nothing else, you know, nothing bad would happen. So I videotaped the whole thing and he was cursing them out, fighting them. They could not get him down. He was resisting. And eventually they ended up getting him down. And the whole time he had his mother on the phone listening. And they ended up arresting him. And he got out like 2-3 weeks later. His mother bailed him out again. He got out. And eventually, you know, they called me. Henry County called me and asked me did I want to testify against him, because the police was already testifying against him. And I told him yes, because Mr. Anderson need help. He has alcohol problems. And I went, but they didn't let me talk. They let the police give their statements, and then they violated him for probation violation. So he only did 6 months.
So when did Henry County take him into custody?
On his birthday, December 13th, 2022.
And was there something that happened with the Yuba Walk residents right after that?
Yes, right after I left the courthouse. His mother said nothing to me or Mia at all. She'd say nothing to her granddaughter. She don't call them. She don't say nothing to her granddaughters. It's like she don't like them. He forces her to talk to my kids. He forces her to call. He forces her to talk to my kids. And it's very sad that he put a wedge between his kids and his mother, because she's taking his side all the time. And few days later, they got a knock. The kids called me at work and they were scared to open the door. And I told them not to open the door. So I got home and they told me it was the sheriffs at the door giving me an eviction. His mother's being vindictive, wanted me out. So, and Edward, he wrote a letter from jail saying he wanted me out. And went to court, and the judge was gonna, it was so many evictions that day, they had to give me another judge. And we was the first ones that got called out. She had 2 men there that I never saw in my life, and helping her. And they had investors calling me, trying to offer me $1,000 to move. And I said, $1,000? That's not enough, you know? I got 17 years worth of stuff in here. My daughter was about to graduate 5th grade, and she was so upset that we had to move. There's so much stress. So we get to court, and the judge wanted us out in 7 days because Edward wrote a letter with his mother wanting us out. And eventually my oldest daughter, ended up convincing him to let us stay for 90 days. And we got put out. We had to move by March 1st. And we got out 17. And it was so hard. We didn't have no money. So eventually my income tax came in. Thank God, God works in mysterious ways. My income tax came in and I was able to get an apartment down the street, which Maya had to go to another school and was upset because she'd been at that school with her friends since pre-K. So she said, why is her father doing this? And I said, I don't know. And then Mia had took a semester off of school, Georgia State, because she's so stressed out that we didn't have nowhere to go, no money. And then he gets out in June and bragging that he has sold the house and has money and bought a car and has new clothes on and sent me a picture of him. And he's supposed to get his teeth fixed for thousands of dollars. And I'm like, why did you didn't send no money to help if you sold the house? And he said that's his mother's house.
Did he tell you how much it sold for?
$155,000. And he's trying to tell me she had to pay the taxes and this and that, but she didn't send no money to even care about where we live at. I barely can afford to where I'm living at now. And I can't even work. Yeah, that's him right there. He remodeled the downstairs. He got new sneakers, new outfit, a chain, a new phone. And we over here struggling. I can't even drive no more because I can't think right because of my high blood pressure. My high blood pressure been up 180 over 120. And by law of DOT, I can't pass my DOT physical because I'm under a lot of stress because Mr. Anderson thinks it's a joke.
Miss Elliott, as you can see, I am showing you what's marked as Plaintiff's Exhibit 11. Can you identify this document?
That's Mr. Anderson with his new clothes, new phone, got a chain on, nice sneakers. And look how he remodeled the floor downstairs because they had a flood. And look like he remodeled the floor and got a new bed.
So he sent you this picture of himself?
Yeah.
When did he send this?
I want to say September.
So September this year.
September this year, yes.
And do you know his purpose in sending you this picture?
Oh, he wanted to show me how he lost weight and how he looks good and he got new clothes and he remodeled. But
Can you identify this document, Miss Elliott?
Yes, that's Mr. Anderson in his room and new sneakers and clothes and chain and new phone.
Okay.
Oh, that's his car, his new car he sent me. He got a BMW. He said it's a 2017 with peanut butter seats.
And this was a picture he sent you?
Yes.
When did he send you this?
It had to be around September.
So this was after his release from incarceration?
This year. Yes, September of this year.
Okay.
He was bragging. Said he always wanted to get a BMW.
Do you know any other reason why he would send you this picture other than bragging?
Bragging and just letting me know that his mother's gonna always help take care of him, and he gonna make me struggle no matter what.
And this is an accurate. I'm sorry.
He was bragging about selling the house and how much money they got, and we don't have nothing. We barely making it.
Your Honor, we tender Plaintiff's Exhibit 12. Miss Elliott, you said that you're frequently in touch with Child Support Services.
Yes, I call all the time. But now they say you don't call. You got to put it on the website and you file a complaint with the website.
Can you identify this document?
Yes.
Can you tell the court what that is?
Hold on, I can't see. Oh, that's, from the child support stating that Mr. Anderson, he didn't participate in the fatherhood program. Yes, that's my tax returns.
For what year?
Last year.
And is this a true and accurate copy of your tax return that you filed for the 2022 tax year?
Yes.
You testified earlier that you have stayed in the same line of work over the years. Is that correct?
Yes, but just now recently I can't drive because I can't pass my DOT because of my high blood pressure. So I work in a warehouse.
Okay. Your Honor, we tender Plaintiff's Exhibit 14.
Plaintiff's Exhibit 14. So
you have also filed a financial affidavit with the court outlining your financial status, including your income and your expenses, to the best of your ability and to your knowledge. Is that an accurate document?
Yes.
And your most recent paycheck stubs are attached to it as well.
Yes.
Is that correct?
Yes.
Miss Elliott, you have incurred attorney's fees in having to file this divorce action and seek relief from this situation. Is that correct?
Yes.
Are you asking the court to award your attorney's fees from Mr. Anderton to reimburse you for your fees? Is that correct?
Yes.
And you have attorney's fees in the amount of $5,000. Is that accurate?
Yes.
That's all we have at this time, Your Honor.
Ms. Elliott, you also indicated that with regard to your husband's paying for a Yuba walk, what was the things that you said indicated that you noted that your husband was responsible for Yuba walk?
Yes, he was half partial responsible.
And how?
Excuse me? I didn't hear you.
How did you know that?
I seen paperwork with my own eyes, yeah. And he talked around me. And he made payments with the HOA. The HOA lady, she lived right next door to me, so she comes and tells me things about Mr. Anderton.
Do you know how much monthly payments that Mr. Anderton made?
It's supposed to be $175 a month, but he made arrangements to pay, I think, $250 a month or something to catch up with the.
No, I mean, how much was the mortgage on the house?
Oh, it was no mortgage. Paid cash. No mortgage. They paid $60,000, $65,000, $60,000, I think, when they bought it.
Okay. So how do you know how much money Mr. Anderton paid towards it? Do you know?
He had got a lawsuit, so him and his mother probably went half. I don't know. He kept me out of that department, and he didn't add my name or anything, so I don't know.
And then he was responsible for paying the HOA fees.
Yes, and the taxes. Yes, and the bankruptcy. Yes.
All right, thank you. Mr. Anderton, do you have any questions for Ms. Elliott?
You talking to me, Your Honor?
Do you have any questions for Ms. Elliott?
No, I don't, but I've had time to sit down and listen to Attorney Saab and Ms. Elliott, and I just would like to backtrack on all the information that was provided in that testimony and provide more accuracy, because there's a lot of things that are definitely inaccurate.
All right. Ms. Saab, do you have any additional witnesses?
I do not, Your Honor.
All right, Anderton, you may proceed.
All right, thank you very much, and I'm going to try to be brief. I don't want to hold up everybody's time. My mother received a lawsuit. My mother was misdiagnosed with intestinal cancer. She retired from the New York City Transit Authority. Blue Cross and Blue Shield was her health provider for decades. They misdiagnosed her. I moved her down to Charlotte, North Carolina. Myself and Ms. Elliott received a phone call from a family member, said your mom is in the hospital, she might not make it. We immediately, that was the weekend, Ms. Elliott took off from work. We drove down there that Monday morning. My mother was intensive care, getting ready to go through surgery. Nothing looked good. The prospects looked bad. She made it through it, and she was successful in her chemo. Due to that, she sued Blue Cross and Blue Shield. Took several years. She finally received her settlement. 223 Yuba Walk was the first home that was purchased in Georgia. The second home that was purchased in Georgia was 7013 Fruitwood Court, which we initially decided to make our family home. I never contributed $1 to the purchase of that home, which was $69,000 was the actual sale price. I didn't contribute $1. My mother took care of that. She also put $100,000 on this home with a mortgage. So I never contributed $1 to either one of the properties. I was on there as rights of survivorship, and my mother did that because she wanted me on there just in case something happened to her. Long life is not guaranteed. She wanted to make sure that was good. She bought the house for us, for myself, Miss Elliott, and the kids. That's why she went ahead and purchased that house. That house was for us initially. So I never contributed $1 to that. With regards to the taxes, you could go back to the Gwinnett County taxes. My name is never stated on any of the tax records. And she has an attorney who could look that up and verify that. I helped contribute to pay to the taxes because my mother purchased the home for us. So I felt the obligation. Okay, she paid cash money for this house. Of course, I'm going to go ahead and pay the association fee. Of course, I'm going to help with the taxes. There's no mortgage. Miss Elliott was living mortgage-free, rent-free. Of course, she'll complain that I wasn't the handyman. That's not my specialty. But there's a lot of women that would be glad to say I can live somewhere and don't have to pay anything but utilities and her own personal expenses. Also, went to we go back to my various issues with the court system. Yeah, I had a rough 5 years. I lost a brother. I lost a daughter, my firstborn, in 2019. But of course, she'll gloss that over because it only looks good to talk about her issues. I should have went and got help at that time. I didn't do it. I still tried to push on. So with no support from Miss Elliott, I wind up finding support in women outside of the home, women that I could talk to, women that at least at that time offered a listening ear to me. I couldn't go home and get any support. So I honestly admit my infidelity. I don't shy away from anything. I admit that. We've been together since 1997. Ms. Elliott has been complicit in some of the physical altercations that we had, but I never took the time out to video, record. I'm from a different era. I thought she was too. We work past it. We try to deal with it. If not, we separate. It could not have been that hard, that bad to stick around for all those years. I find that hard to believe. It sounds good, but I find it very hard to believe. When I went to court and got sentenced in December 13, 2022 in Henry County, because again, I admitted to violating my probation, Ms. Elliott was there with my then 20-year-old daughter, Mia. My mother doesn't drive. She wanted to come to court with me so bad. I'm going to be there with you. I'm going to be there with you. She's now 85. She suffered cancer again a couple of years ago, stage 4 lung cancer, and she beat it. And of course, I'm going to ride or die with my mother. They don't get along. I can't do anything about that. They have a long history together. When that judge sentenced me to a year and I having to do 6, my mother walked out. She sat on the bench. Miss Elliott and my daughter came out laughing, chuckling, giggling. Where was the hurt and pain when I was getting sentenced to a year in jail? Obviously, you were going to have to. She would have had to take care of herself financially during my incarceration. So when did things get so tough that you were unable to provide for yourself and our daughters, one being a minor? Before I went to jail, before I went to court and went to jail, I called Miss Elliott multiple times during the day, because she says I only calls at night because I have a drinking problem, correct? Called her plenty of times during the day. No response at all. I missed 2 birthdays, calling, no response at all. So that's completely inaccurate. And again, like I said, the only reason I went over there is because I reached an emotional boiling point that evening. And I said, you know what, enough is enough. We're still married legally. They're still living in the same house. I'm paying child support, which is another issue I would like for Ms. Elliott to explain to Ms. Sapp. How can you file child support on a man that's living in the residence? But that's a whole nother issue. That explains the arrears, because I was still paying the bills in the house or helping. I didn't take it serious. So I'm still in the house helping to pay bills, but my child support is accruing. Again, Ms. Sapp stated that she asked Ms. Elliott about the difficulties in her receiving child support. I work for American Coach Megabus Southeast. When that child support order came in 2018, immediately my check was deducted $1,025 every 2 weeks from 2018 to 2020. Laura Gasbarro, she's the head human resource person. I'd be glad to provide the number so she could give that information to the court. That's completely inaccurate. We had an issue. May 2022, we did have a fight. I'm on probation. The police asked Miss Elliott to pack up and leave for a few days. I didn't take pictures. I don't do the pictures. Yeah, but I was scratched up really bad. So of course she showed a lip, a partial lip and a scratch here. But if it was that bad, what I did, knowing our history with Lawrenceville Police Department, I don't think they would have any issue at all locking me up. It's many times that they've been out to the house for me and Mrs. Elliott's confrontations. I don't think that's completely accurate. I never told her how much. Let me backtrack, Your Honor. The relationship is so bad, but yes, she can recall conversations allegedly that we've had. So apparently we can sit down and have conversations. Yes, I sent her a photo of me. Yeah, I was feeling good, looking good. I wanted my daughter to see a picture of me since I couldn't have any communication with her. Show Maya her dad, who she hasn't seen since that incident on October 7th, 2022. I'm pretty sure she refused that. Clothes, why are clothes an issue? How do I take a picture? I'm supposed to be clothed. I don't have on expensive name brand clothes. I'm dressed. That's what I'm supposed to be. Yes, my mother bought a car for me. Absolutely, she did. You know why? Because when I got arrested in December 13, 2022, the car that I purchased couldn't make the payment. So now I'm on the hook for $20,000 because it got repossessed. In addition to $20,000 for that, I owe child support $31,000, right? Which I'm responsible for $1,025 a month. I did a modification. Yes, I did, because the original child support order was put in 2018. It is now 2023, and Mia Anderton, she turned 21 July the 26th. So I don't think that should be a problem submitting a modification because one of the kids are timed out. Am I right? Wrong? Should I not say anything? Just let the meter run on too? I don't know. I don't think so. Yeah, Ms. Elliott, she made a lot of statements today. I have no issue with the divorce at all. If it makes her happy, I just want peace. And I hope that if she's found a place of peace without me in her life, I'm happy, because we still have a 12-year-old that's still growing and developing. So if she's happy, her mother's happy. The only thing I asked for, what's rightfully mine, I feel, not being arrogant, is to continue a relationship with Maya, who's 12. And again, I asked that with everything that's been documented, if we went down a list and had exhibits for our 25 years, it would be a tremendous reality show. It would be a tremendous reality show. You would definitely have more good times than bad. And yeah, we came up not knowing anything. Neither one of us had good role models on how to be married, but we found a way to make it work. And we had inconsistencies along the way, and sometimes that's a part of life. Only thing I'm asking for is a continued relationship with my 12-year-old, either voluntarily or through court mediation. And again, as far as the financial aspect of that, I had no financial invested interest in 223 Yuba Walk. Yes, I resided there. Yes, I made statements. Absolutely, I made statements. But the statements does not support the facts. The facts that my mother purchased that property was her money. Go to Gwinnett County Tax and look at all the tax records. You don't see Edward Anderton on those tax records at all. And I wish you the best. Still love you. Got love for you. And that's it.
Mr. Anderson, you filed bankruptcy.
I should have.
Did you list the house?
I had to, because my mother put me on the deed. I did. And when your mother gifted
the house to you, correct?
I'm sorry?
She gifted the house to you?
It was a house for us. It was a house for us, for myself, my wife, and the kids. She bought it. She said, I want this to be for y'all so y'all can have your own space and place.
Right. She gifted the house to you and put your name on it.
Right as survivorship.
And as a result of that, you felt obligated to pay the taxes and the homeowners association fees, correct?
I felt obligated because we had no mortgage, we had no rent. My mother, she paid $69,000 for this property. If the only responsibility I had was helping to pay the taxes and paying the HOA, I was definitely going to do that because it was a blessing.
Right. And so when did it become not a blessing? When was it taken back? I don't know how do you have a gift? Mother gave you.
The house was taken back, or?
Well, didn't she take the gift back?
I would never say it was a gift. She said, I'm buying this property. This is for you and your family. So she never stated, I'm sorry?
So what is that then if it's not a gift?
I mean, if we had to look up the terminology for a gift, I would say it's a gift. I could go to Webster's, but I know we tight on time. But when the property sold, it was already going down to the federal court on Russell Street. I tried numerous occasions to reach Miss Elliott. Again, Miss Elliott fails to tell the court that she refused to have any communication. She cut off all communication.
Mr. Anderton, how much did the house sell for?
What happened?
How much?
The house sold $89,000.
$89,000?
Yes, ma'am.
How much of that did you get?
I got none of it.
How much did you pay?
I wasn't there for the signing.
Mr. Anderton,
yes,
Mr. Anderton, how much does the bankruptcy documents indicate that you got?
No. The bankruptcy was before this house closed. This bankruptcy goes back to about 2013, 2014. This is years before my mother sold the townhouse.
Wait a minute. I thought you said the townhouse was sold during a bankruptcy.
No. That's what Miss Elliott and her attorney told you. I never told you.
The house sold outside of the bankruptcy?
Yes, ma'am. The house sold while I was incarcerated, 2023. My bankruptcy was back in maybe 2012, 13, 14.
How much did you get for that sale of the house?
I didn't get anything for the house. My mother was the sole purchaser, and she was the sole recipient of those funds. I didn't get anything. There was no check for me. I signed nothing.
How much did the house sell for? $89,000?
Yes, yes, it did. Yeah.
So your mom received $89,000?
Yes, ma'am.
All right, for which she bought you a car?
Yes, which she did.
You didn't get any of the other funds?
I didn't get for the house. What happened? This house was in much needed repair. When I got out, she told me everything that she wanted to get fixed. But she's 85. She doesn't have anybody but me. So when I got home, the first thing I started doing was trying to find contractors to start making repairs. So I didn't get anything. If I asked my mother for something, I called my, hey, I need a couple dollars. I need to make a payment. I need to do this. She's going to help me. But never did I receive a lump settlement, a lump anything out of that. Nothing handed to me. And I didn't start going back to work. I had to pray to God that I could still be able to have the job at the company that I was contracted with. And I finally was able to achieve that in July of August. The money is not the same as it was in 2022. And that document that Ms. Elliott provided with you, she stated that she found that paperwork lingering around. No, the day that we had our issue, the final breakup, and she took the picture with me and Ms. Linda Cummings, which is accurate. She's a friend. She took the picture. She was taking me to CarMax in Beaufort so I could pick up the car that I purchased. By the time I got back from Beaufort to Lawrenceville, the lock was illegally changed. I went to Lawrenceville and had an officer escort me back on that day to the house. She was home. She would not open the door. The officer told me, you have to go to court if you want to get any of your personal belongings. I told the officer, I said, forget it. I said, because by the time the court proceedings take place, I'm not going to have anything there. She printed those documents out.
The money that you got from the house, you owe $27,000. Your position, you owe $27,000.
To who?
Oh, I thought you owed for child support. Aren't you behind $27,000?
I understand that's what it is, but I don't. Again, I make payments to the best of my ability. I do not have those funds to make that payment.
But you said your mother does, and that she would.
My mother had the funds to make the payment, but most of the repairs, most of her money was spent into repairing her home. This is her home. It's not mine. And
but I thought it was yours. Didn't you say she gave
No. I'm talking about Lithonia. I live with my mother in Lithonia, Georgia, ma'am. We're
not talking about the Lithonia, Georgia house. I'm talking about the house that Miss Elliott lived in.
Yeah, that we lived with together. Yes.
That house sold.
It did. Yes, ma'am. And I gave you the figure that it sold for.
You're on the deed of that house.
Does it show me currently on the deed?
I'm sorry?
At the time the house sold, I was not on the deed.
Did you come off of the deed of the house?
The investor said he couldn't do anything for my mother because I had right of survivorship on that property.
And you had to come off of it. So you had to give away your interest in the house.
Yeah. Yes, ma'am.
And you did that.
I had to because it was for my mother. The bankruptcy, the HOA was about to take my mother's home. That wasn't my money. That was my mother's.
But it was your money because for 17 years you said you paid the HOA and the taxes.
I didn't pay it for 17.
You had an interest that you let go.
Yeah, I insisted in paying on the HOA, and I appreciate the backtrack, but I stopped paying on that. That's why I had to file for it because I wasn't paying it. My mother wasn't paying it. They weren't doing anything.
Okay.
So I did not pay consistently on the property for 17 years. No,
that's not what you indicated.
No. But I'm telling you, that's why the bankruptcy took place.
You just told me you walk had nothing to do with the bankruptcy.
No. See, I didn't do that. Yuba Walk had everything to do with the bankruptcy. I filed bankruptcy in 2012, 2013. Myself, Miss Elliott, and the kids. That's where we lived. That was home.
Why did you file bankruptcy with Yuba Walk if you didn't own Yuba Walk?
because my mom put me on there for right of survivorship, she was unaware that she didn't do a will until a few years later, which if anything happened to her, her property would transfer to me. When she bought the home, she put me down right of survivorship because it was for me and the family.
Mr. Anderton, do you realize that when you file for bankruptcy, you swear under oath that that house is yours? You do know that, right? So either you purchase yourself now, or you purchase yourself then. Which one? Because somebody, there's some inconsistent information. So,
all right, the thing is,
when are you purging yourself now, or did you purge yourself?
No, what I can't do is once you bring perjury into conversations, that puts me in a place where anything I say is going to be misconstrued as true or false. I've given you the facts. So if you're stating that I'm possibly committing perjury, I'd rather go ahead and have an attorney help me out and request a continuance.
We're not granting any continuances. What I'm saying to you is that if you said it on your bankruptcy that the house was yours, and now you're telling me under oath the house isn't yours, something is.
Ma'am,
you can't have both.
There's no inconsistency. When I went to file a bankruptcy, they said, "Is your name on anything?" I said, "Yes, my mother has me on her property as right of survivorship." Once I told them that, they said you have to get on that. You got to be put on that. That's why I got put on that. I'm not here to debate with you. I completely respect what you're saying, but I'm not perjuring myself. I'm not lying. I've been completely honest since we've been on this transmission. But as your honor, once you start stating words to me that could possibly put me in jeopardy, then I have to request to get some type of legal assistance, because that means I can't battle a court by myself using the verbiage that you put out. Respectfully, I can't do it.
All right. Any additional questions?
I do not, Your Honor. I would like a brief rebuttal. I just need a few minutes to obtain a document to do that.
All right. It's 1:30 to start this other hearing, so I'm going to give you a few minutes, and then I got to start another hearing. All right, Mr. Henry, where were you?
Ma'am?
Where were you?
I had to use the restroom. I'm sorry.
What's your issue, Mr. Henry?
My issue is the from last year of my daughter's senior year in high school. Ms. Lewis, they moved to Virginia. She didn't tell me they were moving to Virginia, and she contended that because she was 18, she could move to Virginia. However, but my daughter was still a senior. She did turn 18 in high school. She was a senior, so she didn't let me know that. But from conversation with my children, they stated that the support that been coming out of my check was not used on them while they were in Virginia. So I found that odd, because it's not like I wasn't paying it. It's not like she didn't get it. So after just further discussion, just finding out she left my daughter up in Virginia just to live with her brother, who was also on the order, but never provided any type of funds from the child support that I provided. So only thing, I don't want the money personally. I just wanted her to pay to the period that she was in high school in Virginia. I wanted her to give that money or use that money for the children as it was intended for, but that wasn't the case. And I wanted to.
All right, what are you doing? You're saying that you want her to take monies and give them to the child?
Yes.
Okay. Is that it?
Yeah, I don't want the money. I think she may have thought that maybe I wanted it. I don't want it. I want the money to be given, because from what I read, if she went up there, my son's was married, grandson is up there, and everything. He aged out, whatever you may call it, but he was still on my order and everything. So I kept paying fine. But when they moved up there and she left her up there, he became like her guardian, essentially, because she was 18, yes, but she was still in high school. She was still a senior in high school. So none of the money, there was no money given for support out of the money I gave for bills like that, or things of that nature, and as well for him in his home while my daughter was there, his sister, or money to her for her, I guess, personal care, well-being, and things like that. And I just
how much? What time frame are you talking about?
it'll be, okay, we're in 23. She graduated last year. So it would have been October, well, October, November of 21 till I believe June of last year when she graduated.
June of 2022.
Yes, ma'am.
So there's 8 months worth of monies that you think should go back to you so that you can fund.
If they don't have to go to me. If that's fine. They can. It needs to go to them. It doesn't. I don't know how. I'm not. I don't know the word to use, but if it doesn't have to go back to me for me to give them. If it can go to them, that's fine. But I just don't think it's right from the conversations I'm having, which, like, it's not like I pride anything, and to find out that money's coming out, but it's not being used for the child.
Okay.
And I'm not saying, and I'm definitely not going to get in here and say she's been a terrible mother. I'm not saying anything like that. I'm not going to say that. I'm just saying for that time period, those monies need to go to the children. And I'm not trying to cancel my arrearage. I know I'm in an arrearage now. I'm not trying to cancel that. I'm not trying to do any of that. Just that portions of those monies need to go to the children.
And Ms. Wills, what's your position?
Your Honor, I see Mr. Henry's request as being biased, being that during the time frame that he's speaking of, which is October the 4th, when I left Columbus and moved to Virginia after our daughter turned 18. That was during the time when I experienced severe trauma, and I chose myself to remove myself from the environment in which that trauma was caused. I moved with our son in hopes of being able to breathe and find out what I needed for myself. I lived with our son and his wife with our daughter from October 4th, 2021 until January 14th, 2002, in which at that time I was forced to leave Virginia due to an incident that our daughter-in-law and myself had regarding her having an accident in the car that our son bought me as a gift and wanting me to lie to file an insurance claim. So I had to make a decision, either get into an altercation with her and lose my freedom or come back to Columbus in hopes of having somewhere to stay. During the time of my absence from my daughter, I still supported her. I traveled to and from Columbus to Virginia. I also sent money to help her with school, prom, and graduation. Outside of that, when living with our son, we had an agreement that I paid him a certain amount or help out as much as I could due to my circumstance, in which I did. I failed to submit those documents because I was unaware of how to pull up the receipts in Cash App. I just recently found out prior to court, but due to the statement that was sent, I was supposed to send that in a sufficient time frame. When I found out that time frame wasn't sufficient, so I was unable to submit those documents.
All right. I'll come back to you in a moment. Ms. Alba, you ready?
I'm sorry, I was muted. Let's see, is Mr. Anderton here?
Mr. Anderton, please come back.
My apologies.
Mr. Anderton, you testified just a few minutes ago that the Yuba Walk house sold for $89,000.
That's what my mother received. Yes, ma'am.
Okay. Are you sure about that?
I'm 100% sure that's what my mother got.
Are you sure you don't want to change your answer on that?
The reason why is because there were other expenses prior to whatever the sale was. There were other things that needed to be paid, and those things were explained to my mother. I wasn't privy to that information, so I would have to look at her documentation.
Okay.
But my mother's not a liar, so if she told me that's what she got, that's what she got, and I'm pretty sure her documents will prove that after all the expenses were deducted. Okay.
Mr. Anderton, I am going to draw your attention to Plaintiff's Exhibit 16. Okay. This is a print off of Redfin, which is a real estate listing service.
I'm aware.
I'm sorry. Hold on just a minute. Can you see?
I can see a hazy photo of the property. I'm very familiar with the property, yes.
Okay, and that's The print at the top says 223 Yuba Walk, Lawrenceville.
I guess I got driver's vision as well. I can't see it too tight, but I listen to what you're saying.
And you recognize that as the property at Yuba Walk, correct. Is that correct?
Correct.
Okay. I am going to show you on page 2 where it says about this home. Do you see that?
I would have to get a screenshot and be able to enlarge it so I could see it properly, but I could see wording, but it's not quite clear to me.
And this is on the screen pretty large. It says 223.
For you it is.
223 Yuba Walk.
Correct.
Is a 1584 square foot condo with 3 bedrooms and 2 bathrooms.
Correct.
This home is currently off the market. It last sold on June 2nd, 2023 for $155,000.
Okay.
The source, it says, is public records.
Okay.
So do you want to revise your earlier answer that it sold for $89,000?
What I will do is I will be able to provide documents to the court that wasn't the actual check that my mother received. And I can do that without an issue. And I don't think my mother would hide $60,000 plus $70,000 from me. It's not my money, but she wouldn't deceive me and say that's what the check was for. And I'm willing to do that immediately. You
say that that you had no ownership in this house, and yet you were paying taxes, you were paying expenses, you said you were looking for a contractor to come in and repair?
No, ma'am, you are getting it confused. I said contract for my mother's house. Please be on point and be specific, and don't put 2 different pieces of the puzzle together. The contractor was for when I got released from Henry County. My mother's house was in desperate need of repairs.
Which house?
So, in Lithonia.
Okay, so you're assisting your mother with paying expenses on the Lithonia house.
No, ma'am. I said finding contractors. My mother's 85. She doesn't use the internet. I'm her only son. My 2 brothers are dead. She has no other immediate family, ma'am. So I'm the brain for my mother to help her. She's old. She has the right mind, but she's not in great shape business mind.
And she recently bought you a car. Is that correct?
She did. Yes, she did.
It's the BMW?
Yeah, and it's not a 2017 like Miss Elliott stated.
All right. That's all I have for this witness, Your Honor.
What year is the car and how much is it?
It's a 2013. I don't know the actual value, like $10,000, $11,000, and then it was taxes and fees.
All right. Anything else?
No.
I do. I know this is not a criminal proceeding; it's a civil proceeding. But you said, Your Honor, that there's no continuances allowed, or if there's additional information that needs to be provided, can that be provided to shed more light and accuracy on what's trying to be betrayed as far as the monetary amount, what the house sold for, whose name was actually on the tax records? I think that should have got pulled up while we were looking for what Redfin, has the house listed for. Go to Gwinnett County taxes, and if you could pull it up, nowhere will you see my name on those tax records.
All right. Nowhere. So what I'm saying to you is I get to decide if I'm going to grant a continuance or not, and I'm not. I'm not going to grant it. I'm not going to grant a continuance.
Okay. Well, can I be allowed to provide my financial affidavit to show my current expenses? Because I had less than 72 hours when I received this information. I started receiving information Friday and Saturday. So I had no advance notice there was going to be exhibits. I started receiving exhibits via email Saturday evening. So I was completely blindsided.
You're not blindsided. You just are not. You're just a lay person, so you don't know the process.
Okay.
Your case had been on since February of 2023, I believe. So, yeah. So you've known you're going to have a hearing. At some point, you're going to ask for a divorce, right? You're not thinking that
you said I was going to ask for a divorce?
Well, at some point, you knew she was going to ask for a divorce. How long did you think?
I was aware in February, yes, ma'am.
Right. So you're not blindsided. You didn't get the information, but you knew you had to collect information and you understood what she was asking for. So I don't think you're not being blindsided. You just didn't.
Yeah, but regards to not finding out maybe a week ago when this actual court date was, maybe.
No, the court date was emailed to you on the 20th, which was 14 days ago.
Emailed to me or a contact?
No email.
I didn't get my information to Ms. Marshall until maybe a little more than a week ago, because I had somebody else while I was incarcerated. They had volunteered to help me out with the process, and I emailed Ms. Marshall, and I advised Ms. Marshall that that individual suffered a stroke and is no longer capable of reading or corresponding to anything. So I provided Ms. Marshall with my email. So respectfully, I don't think it was 2 weeks ago.
If you want me to take your financial affidavit, I will.
I appreciate it.
Linda, can I say something? Linda Cummins, which is his girlfriend that was in the car, she the one that did the paperwork.
Sorry. Oh, yeah, I understand. Yeah. That's not my issue.
Yeah.
All right. Any final comments? I need those. You got 5 minutes.
I'm sorry, is this closing, Your Honor? Is that what you said? Mm-hmm. I'll reserve.
Mr. Anderson.
I would just like to thank everybody for their time. And there's been a lot of defamatory statements made about me. And I guess that comes with the territory. But again, I respect everybody that's involved. And I like to say something on a law level, right? We might understand this. I learned this. You have the facts and you have law. And if you don't have the facts or law, you beat the table with your passion. So I haven't been able to beat the table with my passion because it looks crazy. But you said I was a layperson, which I am. But if you feel strongly and passionate about something, if you know what you're talking about, it might not be law-driven or law terminology, but you know what you know. And if I would have had the money, I would have had my crown put in. Now look, I didn't have a crown. I still don't have a crown. Still walking around listening to. So I look forward to being able to provide that information to the court as far as my financial affidavit. And Your Honor, where could I forward that information to once I get it notarized?
You can, what do you mean get it notarized? You don't have it notarized right now?
I don't. I just printed it out. I received the information from Ms. Saab in her lawyer's office. So I had to go online and through the, I guess, support of like a legal aid website, I was able to print out the information. I have all my documents here. I'm going to go ahead and go step by step and fill everything out.
I'm not taking information that's done after the hearing. I thought you had something now that you want to submit during the hearing. I would take that. I'm not taking information.
Okay. Well, we'll start off by currently being in the arrears with child support for $31,353.83. So that number that Ms. Elliott and her attorney pulled up is not up to date. In addition to that, I'm still trying to make out arrangements, but I owe the IRS $6,029.40. I owe the IRS $2,714.70. I owe the state of Georgia, which if you were selling a home and your name was on, you'd probably be in a bond, $5,690.80. I owe American Credit Acceptance when I purchased my vehicle in 2022 in excess of $20,000. And those are just the big bills. So by being incarcerated the last 6 months, I've been trying my best to catch up. Now, if I had all these great resources, a lot of this stuff would have been taken care of already, but I'm just trying to play catch up, and I look forward to the new year so I can get back on track. I'm going to continue to make payments to Maya. I love my baby to death. The only thing I ask is, with God's blessing, I'll be able to get to see her, because I believe Ms. Elliott plans on moving to Connecticut shortly. So when she does that, that's going to create another issue for me. She's not going to tell it, but that's what she plans on doing.
I appreciate your indulgence as well, Your Honor, and I'll make this quick because I know you have other business. I want the court to think about Mr. Anderson's opening statement, where he blatantly told the court that his name was never on that property in Gwinnett County, and he was quickly shown to be lying about that. And he has talked in circles. He has made up numerous lies to cover up previous lies in his testimony. He has no credibility, and the facts speak for themselves. Miss Elliott has been a workhorse during this marriage. She has basically been a single parent in a lot of ways. Now, he did provide the Yuba Walk residence, for her and the children to live in. So that's to his credit. But when she reported him for violating his probation, as she should have done, then he and his mother behaved in the most punitive way possible and evicted he signed a letter saying, yes, I agree with this eviction. That was just absolutely nothing other than revenge. And to do that, especially to a minor child, is inexcusable. And he presented no evidence to counteract that that is in fact what happened. That eviction was just out of revenge and for no other good reason. And you heard Ms. Elliott testify that having to immediately find a place to live, that put her in a bind, and it affected the school district of her youngest daughter. It was a terrible situation for the family, financially painful, emotionally painful, and none of that had to be. I mean, this could have just been a simple divorce and everybody go their own way. But Mr. Anderton has created massive financial pain for his wife and his children. And that should definitely be accounted for in the court's ruling. There is no reason why he can't pay this arrearage, and definitely more than at the rate of $50 a month. When the child support service issued that arrearage order, the house had not been sold. So the sale of the house is fairly recent. And the evidence is that it sold for $155, just like he told my client that it sold for. And clearly he did receive funds. Why else would he take a picture of a car, take a picture of his new duds and jewelry? Why would he do that and send that to his wife? It served no legitimate purpose other than to rub her face in the fact that he was out of jail and he had defied what she had done to him by putting him in jail. And here he was, footloose and fancy free. He had money. He called her to brag that that house sold and that she had not done anything to him at all that he couldn't overcome. Your Honor, we ask that you do grant the divorce. We ask that you grant sole legal and physical custody of Maya to my client. We ask that you grant her half of the proceeds from the sale of the house, and that is the $79,000. Inclusive in that is the recognition of this arrearage that is now that, and I appreciate Mr. Anderson's honesty on this, that it is now $31,000 because she's just not going to see it any other way. If he's a 1099, she's going to be chasing this forever for her child. And he has this huge sum of money that he's come into ownership of. At least legally, he has ownership of it by virtue of the fact that, yes, he did have joint right of survivorship. When people are joint tenants, that's what they have. He owned this house just like his mother did, and in the eyes of the law. So we ask that you grant that amount to my client. We ask that you grant her $5,000 in attorney's fees, and we would ask for a restraining order that would be contained in the divorce as well, Your Honor. Thank you.
All right. So I do want to have an opportunity to speak with Maya. So I do want to do in chamber meeting with Maya. So we'll set that up. So I'm going to hold the order out until I've had an opportunity to speak with her. I think that there are a few things that kind of hits me really hard. Mr. Anderton, I think you need to listen very carefully to this because you're young and you're going to date more. I don't know about the old ways that you're accustomed to because I'm 52. Mm-hmm. The old ways of we don't take pictures, we just take whatever beatings we get. That is over. No one is going to allow you to continue to put your hands on them and say that the old way is that we just keep it to ourselves. No, domestic violence is against the law. And you can't do it. You can't knock over doors because it's your house. You can't call your daughters out your name because they're your daughters. You cannot do those things. And what came across to me, Mr. Anderson, is that you think that because she was able to take it for 17 years, that it is okay. No, I'm going to send you your transcript. Mm-hmm. And I'm going to send it to you because I think you need to read it. Because you'll be amazed what you just said. You probably don't even realize. You said the old way is that we don't take pictures. You said that the old way is that you basically grin and bear it. That's what you said.
I was speaking about myself, having suffered of being complicit with the violence. I don't believe in taking pictures.
Mr. Anderton, please. You said that she had enjoyed this life for 17 years and that it could not have been bad if she stayed in it. That's what you said. You said that there's no way a woman would stay in a domestic violence relationship if it was that bad. That's what you said. Shame on you. Shame on you. For you to think that because she stayed, it was okay. Shame on you.
Your Honor.
I'm done. You've had an opportunity to be heard. I'm ruling now. I
did a lot of great things.
Mr. Anderton,
marriage and
Mr. Anderton, this is the point where you just listen. Okay? Doing great things in your marriage does not offset the beatings.
But you're listening to her give up.
Doing great things for your daughters does not offset that you calling them bitches. It doesn't. It just offset it to you. But they remember it. And you, for some reason, are belittling her trauma. It's a shame. I will grant you your divorce, Ms. Elliott. I would grant you a divorce on the grounds of cruel treatment. However, I've not heard that Mr. Anderton hurt your daughter. And so therefore I'm going to talk with her and see what those circumstances look like before I make any final decisions. Because I do believe children should be raised by their parents to the extent that's possible. So I'm going to have an opportunity to speak with her. Mr. Anderton, you're so bold as to admit your lifelong infidelities. How bold can you be? You literally admitted that you had several infidelities because your wife did not comfort you at home. Wow. I've been practicing. I've been a judge for 15 years, and I ain't never heard anybody admit infidelity. That's how bold you are. No one, you know why no one admits them? Because infidelity equals you got to pay her. And so most times, to prevent that from happening, no one admits it, but you have. You didn't admit it once. You said a lifelong. So she's had to deal with you dealing with other women and coming back home being angry, breaking out the door and fighting her. Because she got free rent, she was living a good life. Shame on you. With regard to child support, you will pay the child support outstanding amount. There are two things I'm going to do. One, I do believe that the law might allow the court to consider that property yours. I need to do some additional research because you admitted under oath, one, that the property was given to you and Miss Elliott as a gift. You said your mother bought it so that you and your family will be able to live there, and that if anything happened, she wanted to ensure that the family was taken care of. That's what you admitted. You admitted that as a result of that, you agreed to take care of all the taxes and the property, upkeep of the property, and that you were doing that for 17 years. That's what you admitted. Right before the sale of this house, you admitted that you gave away all the interest that you had in this property to your mother without any consultation with Miss Elliott. You gave the property to your mother so that she could sell it without you, which means you gave up property rights. You gave up your equitable interest in that property without any funds being given to you, despite the fact that you had taken care of this property for 17 years based on a gift your mother gave to you that was specifically in your name, that you moved out of your name during a tumultuous time of your marriage. Doesn't look good. Looks like constructive fraud. You admitted that in your bankruptcy, you admitted that the house was yours. So it doesn't look good, but I'm gonna just do some additional research to see if that's sufficient. May or may not be, I don't know. I'll do some research on it. Despite that, you acknowledge that your mother would help you whenever you got into financial difficulties. Well, Mr. Anderson, you're in a financial difficulty because you owe $33,000 and you have a $10,000 car paid in full. Okay? So, you can sell your car if you want to or not. You can ask your mom for it or not. I don't care. But I'm going to give you 45 days to pay the $33,000. That's what you got. 45 days, $33,000. And we already know you got 10, that you got a car that is paid in full. Did I miss anything, Ms. Saul?
Attorney's fees?
Granted.
Thank you.